Thank you. Welcome to the third hearing of the Portfolio Committee Number 5, Justice and Communities, for the inquiry into budget estimates 2024-25. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders, past and present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Robert Borsak and I am the Chair of the committee. I welcome Attorney General Daley and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for portfolio of Attorney General. I ask everyone in the room please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide for procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. To all the witnesses, welcome and thank you for making your time to give evidence. All witnesses will be sworn prior to giving evidence. Attorney General, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. I also remind Mr Tidball and Ms Campbell that you have already been sworn before the committee during this inquiry and therefore you do not need to be sworn again. For all other witnesses, could you please state your name, position, title and swear either an oath or an affirmation. Please begin with the first witness to my left. You, Ms Hitter.
Thank you, Chair. My name is Monique Hitter.
Could you maybe pull the mic a little bit closer in?
Certainly.
You might all do that because it's sometimes a little hard to hear. And voice up if you can, please. Thank you.
My name is Monique Hitter. I am the I'm the CEO of Legal Aid New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Chris Daith. I'm the Acting Deputy Secretary of Courts and Tribunals and Service Delivery Division, Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Paul McKnight. I'm Deputy Secretary of Law Reform and Legal Services at the Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
James Cockayne, New South Wales Anti-Slavery Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Sally Dowling, New South Wales Director of Public Prosecutions. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Today's hearing will be conducted from 9:15 to 5:30 p.m. We are joined by the Minister in the morning session from 9:15 till 1 p.m. with a 15-minute break at 11 a.m. In the afternoon we will hear from the departmental witnesses from 2 p.m. to 5:30 p.m. with a 15-minute break at 3:30. During these sessions there will be questions from the opposition and crossbench members only and then 15 minutes allocated for government questions at 10:45, 12:45 and 5:15. We will now begin with questions from the opposition.
Thank you. Morning, Minister.
Morning, Ms Carter.
Did you ever receive a bottle of gin from the Police Commissioner?
No, unfortunately, I didn't know.
Not even as a legacy, a reminder of your former work as Police Minister?
No, got a boring old cap with a police badge on it from Andrew Scipione, but never a bottle of gin.
All right, it's a shame. You're on the list of those who missed out. Turning to another topic, do you think there's a need for legislative reform to reduce the influx of illegal tobacco into New South Wales, or is this more an issue of enforcement?
I think that's more of an issue for the Commonwealth Government.
So there's no concerns about illegal tobacco in New South Wales at all?
I noticed from reading the transcripts, Ms Carter, that you're apt to begin with a statement which is dressed up as a question. You've just done it then. I'm not going to play that game today, so why don't you draft your question accurately for me, please?
Sorry, so you're complaining about the way I frame questions, are you?
Yeah. Let's just get that out of the way early on.
So do you complain about everybody's questions, or is it just me because I'm a woman you're complaining about my questions?
Well, it's drawing a long bow there. Now, you make a statement, throw a question mark on the end of it, and want to lead me into some discussion where you should just be asking me for to elicit some information. That's the purpose of today's.
Well, I will listen to your critique, but I will reserve the right to ask questions as I think is appropriate for this undertaking. And perhaps you could tell me what your view is about the MV Nami, which was allowed to refuel in New South Wales waters despite carrying 2 tonnes of illicit tobacco. As a former customs officer, do you think Australian Border Force was right to stop the New South Wales Police from intercepting that vessel?
I'm not sure if you look at the New South Wales Allocation of Acts Act, there's the Michael Daley Former Customs Officer Act that requires me to answer questions of that nature today.
I just
Sorry.
thought you might be able to assist us with your personal experience.
No, that's not why you asked me that question, but anyway.
So you're a mind reader now, Minister, are you?
Yeah.
That must be very useful for you.
It is.
Are you, if this is a cross-border issue, are you planning to raise this at SCAG?
Only if it relates to the duties and functions and responsibilities of the Attorney General.
And do you believe it does?
Vessels at sea don't, as far as I can see.
So whose responsibility would it be to raise then to address this issue for the people of New South Wales?
Immigration and Border Force, perhaps police.
So there was a dispute between police and Border Force. Who was right?
I don't know.
And you don't have a view about this matter?
Well, you've done it again.
Thank you, Mr Attorney.
That's
I can
not-
see
that's
that you're
not-
not
that-
interested in answering
No,
questions
in no
from
way
the
can
people
that
of
be
New South
regarded as a
Wales.
question, that last statement of yours.
Well, and so you are hiding behind complaints about my questions to show that you don't really care about illegal tobacco in New South Wales, and you don't really care about this law and order issue in New South Wales.
And there you go again.
So, and there you go again, Mr Attorney, actually not caring about issues that are important to the people of New South Wales. Well, let's talk about knife crime. One of the first bills that you introduced was designed to address knife crime and introduce 93 IB and IC into the Crimes Act, and which doubled the penalties for carrying a knife from 2 to 4 years imprisonment. Is it fair to say that doubling the penalty was considered by you as Attorney General as the most appropriate way to deal with knife crime in New South Wales?
The most appropriate way. I think there are many ways that governments should have at their disposal to deal with knife crime, including education, good parenting. Doubling the penalties for knife crime, as you've described, was one of the responses that we took from opposition when I introduced a private members bill, and then we followed that up when we got into government, and that was.
So therefore, you have a history, as you say, that of seeing doubling penalties as an appropriate way to deal
No, I
with
didn't
knife
say
crime.
that at all. I said that was one of the things that we did,
You
and I did it.
introduced it as a private members bill in opposition. You then did it as one
So
of
can
your
you
first acts of
please
Attorney
don't interrupt
General.
me. You asked me a question, let me answer it. One of the reasons we did that was, notwithstanding the fact that crimes involving knives were stable, we saw that there was about a 50% recidivism rate for people who were charged with possessing a knife in a public place or school. I saw that the issue of people carrying and using knives had, I think, gotten away from the authorities in the UK, and we wanted to make sure we remained vigilant so that knife crime didn't get away from us in New South Wales, which is why we followed up with further amendments in relation to Jack's Law and the like in 2024.
Yeah, you indicated that there were a range of measures available to you, and Jack's Law was already operating in Queensland at the time you introduced that first piece of legislation. Why didn't you introduce Jack's Law at that time?
When you're a new government, in fact for any government, issues arise from time to time. Governments take their time to work out what the best, most appropriate responses are. Sometimes government actions that manifest themselves in legislation can be a result of people making submissions or public inquiries, or in the case of Jack's Law, Jack's mum and dad, who have been advocating strongly and effectively all over the country for the introduction of that. So legislation and government responses arise from time to time as a result of various sources, pressures, things like that.
So you didn't think about Jack's Law at the time of the first legislation, even though it was on the books?
It wasn't considered at the time that Cabinet made its decision, and that was how we decided to respond at that particular time.
And you agree that by doubling the penalties from 2 years imprisonment to 4 years, that you were exceeding the jurisdictional limit of the local court, and since they were Table 1 offences, that any actual awarding of those penalties would have needed to proceed by way of indictment in the district court?
Yes, we were aware of that, yes.
Okay. On how many occasions has the DPP proceeded by way of indictment in the district court in respect of a breach of either 93 IB or 93 IC of the Crimes
I'll
Act?
have to take that question on notice.
Okay. Has the DPP declined to accept the recommendation of the police to proceed by way of indictment in relation to matters in 93 IB or IC?
Unless the director wants to help me out now, I'm happy to take that on notice. No.
Okay. And since your new law was put in place, how many proceedings for offences under 93 IB or IC have been commenced by indictment in the district court?
I think rather than search through these folders for the answers, probably more efficient use of time to take that on notice as well, Mr Chairman.
How many proceedings commenced summarily in the local court?
Again, we'll take that on notice. We'll try and get you an answer before the end of
I understand the importance of detail, and I thank you for paying attention to the detail. But given that this law focused on penalties, and given that the focus of this law was a doubling of penalties, why is it that you are not aware of how many times that double penalty was actually handed down? Because if it hasn't been handed down, has this law been effective?
Because when you ask me a question that requires someone to have compiled statistics, I want to make sure that I answer it accurately. This is not a memory test.
I'm not suggesting it's a memory test. Are you following the success or not of this law that was one of your first pieces of legislation as an Attorney General?
There are mechanisms built into the legislation for reviews. From time to time, Boxar issues its reports. Those reports are contained there. I discussed these things with the Minister for Police and others at the time. Courts sit every day, charges are heard every day. The statistics are fluid on a daily, sometimes hourly basis.
Do you have any evidence at all that this law has done anything to reduce knife crime?
I'll have a look at the statistics and rely on the experts like Boxar to see what the effectiveness of those laws has been.
Well,
however, the prosecution rate and the conviction rate and things like that are one measure of success. I did say in media commentary when we introduced both those laws, and also, if I'm not mistaken, in my second reading speeches, that one of the intentions that governments have when they bring laws like that and others to the floor of the Parliament is for those laws to send a message as well. And I recall saying in press conferences that one of the messages that we wanted to send to young men, because it's almost exclusively young men, with the bringing of these laws into the public realm, was for us to send a message to them to walk out the door without knives in their pockets. And that's one of the other things that legislation brings, a community educational aspect as well.
And you think young men are sitting down reading the New South Wales legislation website to see what you've done to penalties?
No, but when one of their friends gets picked up and they find out that the knife crime's doubled and he got a penalty and a sentence longer than they thought he might, then their ears might prick a little bit.
Which is exactly my question. How many of their friends have actually received double the penalty that was provided for
And I've
in
told
your
you
law?
I'll take that question on notice.
Well, let's look at the Boxar figures, shall we? Because knife-related robbery and assault have been relatively static in the 12 months since you passed that law. Would you agree with that, Minister?
I don't have those in front of me, but I did say to you at the outset of this answer that when we introduced them, crimes involving the use of knives was relatively stable. And I said, notwithstanding that, one of the reasons we brought the legislation to the House was to drive it down if we could. That was one of the measures that we brought.
And the figures indicate that it has not driven it down.
And
In
it's
fact,
it's early days, only a year old, so
And so you wouldn't expect to see any result from legislation in a year?
possibly not.
What's your time frame for
I
legislation?
don't have a
and
time
sub-
frame. That's why we got
Well,
box
Minister,
up.
if you say a year isn't sufficient, what is your
Now,
time frame?
sometimes when you're looking at crime trends, you require a few years for those results to manifest themselves, to get a good sample size so that you can ascertain what the trends are doing.
Well, if we drill down into the box-eye figures, we can see that there's actually been a slight but significant increase in knife crime in the last 12 months. There were 14 more knife assaults on strangers this year than in the year before you doubled your penalties. Is that what success looks like, Minister?
That's a leading question. I'm not answering that.
So you're not concerned that there have been 14
go
more
again.
knife crime
You're
assaults
not
after
concerned.
you've doubled the penalties?
Did I say? When did I say? Can we go to the Hansard and see where I said I'm not concerned?
Minister, you're playing word games with me.
No, I am. Because it's your job to ask me accurate questions today and not play word games with me.
Minister, it is your job to actually be answerable to the people of New South Wales through this forum. You're not playing
Point
word
of order,
games with
Chair.
me, you're playing word
Point of
games with
order,
the people
Chair.
of New South Wales.
Point of order, Chair. The Honourable Susan Carter was not attempting to ask a question there. She was attempting in some bizarre way to lecture the Minister, the Attorney, on what he should be doing. I ask that you ask her to refrain from that.
To the point of order, Chair, to the point of order. I think it is important to note, and that the witnesses should be reminded, that there's no really such thing as a leading question in budget estimates. Questions are questions. It's not a court. And I just make that point. I don't think it really goes anywhere, but I think it's important to remember.
My inaccuracy, I should have said, that's a statement, not
you.
a question.
Thank you.
And to your point, we don't make any apology for introducing tough new laws in relation to knives or any other crime. None whatsoever.
I'm asking you, Minister, do you think your law has worked?
I've just told you that when you are, if you look at publications by Boxar and other crime statisticians, sometimes and in relation to statutory reviews, you need a proper sample size over a suitable time frame to make proper and informed judgments from crime statistics. And I'm not sure with the small sample size over a year that's the case, but I'm happy to take that on notice.
So, Minister, over the past year, knife murders have increased by almost 30%. Do these figures indicate your legislation was successful?
I'd have to sit down and have a look at the statistics and the context around those statistics to be able to sensibly answer that question.
Is there any reason, Minister, why it's been a year, you haven't actually sat down and looked at those statistics and got a sense of whether this law was actually working or not?
There are review mechanisms in place. We track laws, and my department gives me briefings on them from time to time. And I've just told you that you've asked me a specific question about the effectiveness of it. When you're talking about the effectiveness of laws, criminal laws like that, I rely on reports from the experts to tell me about what their effectiveness may or may not be, and I've just gone through with you that with 1 year and a relatively small sample size, I'm not sure that you could ascertain what effects those laws have had on behaviour in New South Wales, but I would have a look at that and take it on notice.
So you react to what the department says. You react to what other people says. You don't drive proactively as the Minister and take responsibility in this area?
No, well, I was proactive, not reactive, when I introduced the laws in the first place, as you
And
pointed out.
have they worked?
I've just answered that question 2, maybe 3 times.
In June 2023, Minister, you said of your knife crime laws, quote, "The tougher maximum penalty will send a strong message about the gravity of knife-related crime," end quote. But this message hasn't been received by those carrying knives in our community, has it?
I think we've just asked me that question in a different way a couple of times.
Well, then
already,
let's
Ms.
jump
Carter.
forward a year, where in another press release you said, quote, these tougher maximum penalties highlight the seriousness of knife-related crime, end quote. What law were you talking about there? The same law?
I don't have that press release in front of me, so I don't know.
Okay, well, I can tell you it was not, even though it was the same words, it was not the same law. It was actually Jack's law. You issued a press release with almost the exact words, almost exactly a year apart. Your message is the same, but is there any evidence that knife criminals are listening to you?
I've just answered that question for the third. This is the fourth time now.
Minister, if you had answered it, I wouldn't need to keep asking it.
I'm not sure that's correct, actually, Ms Carter, but anyway, let's leave it there.
When will Jack's law be proclaimed?
I'm not sure. I think we're waiting for some...
Police.
Yeah, I think we're waiting for police readiness to before that is
Have you
proclaimed.
given a date for which you hope the police will be ready by?
I don't think so.
Okay, so you're not driving it proactively, you're waiting for the police to let you know when it would be a good idea to have Jack's law. Is that right?
Given that it requires the police to purchase equipment and train their officers in the use of it and of the accompanying legislation, yes.
How much money's been allocated in the budget for the implementation of Jack's law?
I have to take that on notice.
Okay. So you can't take me to where in the budget papers that funding's been allocated?
No, I just said I'd take it on notice.
Okay. What advice about the failure of the first knife laws did you receive that was used to shape the second knife laws, Jack's law?
I think you've proceeded upon a misapprehension there. What advice did I receive about the failure of the first laws? Can you table that advice, please?
No, I'm asking you for the advice. I'm asking you. So we have knife law in June 2023, which on boxar measures is not working. Knife crime, if anything, is going up. We have new knife laws in June 2024, Jack's law. Why Jack's law now? What advice did you receive about the first knife laws that led into your decision to proceed with the second knife laws?
Why are you proceeding on the assumption that Jack's law proceeded on the basis that the doubling of knife crime a year earlier was a failure? I don't. Where's the correlation there? Can you table some document or something for me to?
Well, Minister, if you were so confident that your first laws were working to deal with knife crime, why did we need a second bite at the cherry?
Surely that you'll understand that question proceeds on the basis that when a parliament passes a law like to double knife crime, that will then automatically reduces knife crime to zero and you don't need to bring any further laws in. Do you understand the basis of the question you've just asked me?
I understand that you've apparently paid no attention to the success of the first law and that hasn't fed into Jack's law. In budget estimates on Friday, you may be aware, Minister, that the police gave evidence that in terms of Jack's law, we're looking at some trial by Christmas, but, quote, in the second half of 2025, it is more realistic that we have that capability. After the horrible events...
What page of police estimates are you reading from?
It would be... it was Deputy Commissioner Thurtell and... apologies, I thought that was... here it was page 62.
Okay, hang on a tick.
Given that police are saying...
So you... Whereabouts are we going to?
Page
here?
62,
Yep.
Deputy Commissioner Thurtell, about the 1, 2, 3, 4, 5, the sixth paragraph down. I can read the whole thing to you.
I can't tell you exactly. What I can tell you is we're commencing a trial November, December, whenever it is. Then I'm not going to turn around and say it will be fully operational by January. However, I would suggest in the second half of 25 is more realistic. We have much more capability. Is that... Yep.
Yeah. After the horrible events at Bondi Junction, why will nothing really be in place until the end of next year to protect New South Wales from knife crime?
Nothing will really be in place.
Jack's law will not be fully operational till the end of next year.
I'm not sure it's fair to link the introduction of Jack's law with what happened at Bondi Junction, frankly. So I think that I'll leave that question there.
Times it's right.
Crossbench?
Me?
Yep.
Okay. Good morning, Attorney.
Hi, Ms Higginson, how are
Can
you?
I please, very well, thank you. Can I please just take you to another topic? Can I ask you what is happening with the anti-protest law review that is underway? I understand that submissions were closed. You made that a public process, and submissions closed on the 1st of June. And I'm curious if you could inform the committee on where things are up to with that one part you're responsible for.
I think that the statutory review is nearly complete and should be made public before the end of the year.
Could you give us a spoiler or a teaser of some sort? What did the submission say? How many did you receive? Is there anything you can give us any insight into?
I'd have to go and look at the statistics. Perhaps Mr McKnight or Mr Tidball could refresh me on some of the numbers of submissions. About 1,000 submissions, is that right?
Something in the order of 1,300 submissions were received. A number of them were submissions from individuals that had a kind of form that they were how can I put this? Individualised, but they had a kind of form aspect to them.
Yes,
but
which
there
is
were
what
also-
people, which is what a lot of people do
Oh, indeed,
nowadays
indeed,
to
indeed.
mobilise
It's,
and communicate their
perfectly,
desires.
perfectly understandable. And I think I'm just looking for the number of institutional submissions.
Before Mr McKnight gets back to you, I think that the time frame requires the stat review to be published sometime around October.
Okay, okay, so not far away, and
Yeah, that's right. So 6 months. Yeah. Yeah. Must be tabled on each House of Parliament within 6 months after the end of April. So it's first week of October.
yeah, and so we think there's been around 1,300 submissions. And is there as I say, is there any kind of spoiler in terms of what you think and what the feel is within the
vibe? The vibe?
The vibe of the thing. You are the attorney.
No, I can't. No early Christmas presents. I'm sorry, Ms Higginson.
Okay,
No.
but if it comes to the point where there really is, the review is those laws and not really providing any great purpose, and they're no longer particularly relevant, and in fact they could be harmful to democracy, you would consider repealing those laws or letting them die a death that they should?
If those tectonic thresholds were met, I'm not sure they will be. We might consider doing something, but the early Christmas present I might give you is that the government has no intention at this time of repealing those laws.
It's a very, very sad Christmas present, Attorney General.
I'm sorry.
And
I'm the Christmas Grinch.
You know the sentiment of the very active pro-democracy community thinks that those laws are such an indictment on our democracy and our rights to participate.
Yeah, but do you know what, Ms Higginson? Every Sunday or thereabouts, since the horrific events of October last year, there have been people who've been peacefully protesting in the Sydney CBD, cooperating with the police under the Summary Offences Act. They haven't had arrests that I know of. They haven't, they've shut down streets here and there, and they've inconvenienced people, but they've been able to express themselves in a democratic way in the busiest CBD in the nation, and they've been pretty much peaceful. So when people make statements like we're shutting down democracies, I'm not sure that's really
I would
accurate.
suggest to you very strongly that they are precisely the people asking for the repeal of these laws, that has been undertaken in spite of these laws and under very heavy police armed presence.
So you're
if that's your version of democracy, Attorney, it's a very different one to many other
You're
citizens.
suggesting they'd rather stop a van in the Harbour Tunnel or glue themselves to Stony Creek Road than
That's
have a
not what I'm
protest.
saying, Attorney, and
Well,
I'm the one here asking questions
sure.
today. Thank you. Attorney General, could you remind me on who was consulted during the consideration and the making of the new knife wanding powers?
I'd have to go back and have a look, get some advice from the department about who was consulted.
Do you recall talking to the Bar Association about those laws?
I'd have to check. I don't want to be inaccurate about those.
Okay, I don't think you did, but if you could check, I'd be grateful.
Yeah, sure.
Do you recall consulting with the Law Society about those laws?
Again, I'll have to check.
Thank you. I don't think you did. I'd be grateful if you could. Did you consult with the Law Enforcement Conduct Commission about these laws?
Probably not, but
No.
again, if you're asking me a general question, one after the other...
No,
about who I've
I'm
met,
asking you
I'll-
if you consulted with those
I don't-
each of those
I didn't.
professional
I'm
bodies.
not sure if the police did or if the departments, either departments did or the police force did. I don't know.
With respect, Attorney General, I'm asking you because you are responsible for making those laws.
They're my laws, but
They are your laws.
Yes, they are.
And that's why I'm asking you if you
That's
recall
right.
consulting with those three bodies.
But a lot of the consultation was done by the police because they necessarily involve police powers, police activities, police equipment, things like that.
Thank you. Are you aware that Griffith University's review of the knife wanding trials in Queensland found no evidence that the program reduced knife possession or violent offences with knives?
I have had a look at a study by Griffith University months ago when we were contemplating these laws.
And did you read that
And I-
part that I just read out, the bit I read?
Yes, and but I haven't had a look at it since then.
So does it concern you that the empirical evidence shows that really these laws don't do the thing that you're claiming you think these laws do, i.e. reduce knife possession, or as in make people, I think it was your words, leave their home suggesting they won't be carrying knives? I think that's what your evidence was earlier today. And that the empirical evidence is that that's not what these laws do?
Sorry, what's the question?
Are you concerned at all that the basis upon which you are suggesting you've made these laws, the evidence shows that they don't achieve those purposes?
Often when you are considering introducing criminal laws, there are contrary views.
I'm talking about evidence, not views. This was a research paper. It was research done on Queensland's laws.
And the Cabinet decided, based on...
So they're not your laws. It was Cabinet. Were you the...
I'd take them to the Cabinet and the Cabinet decides whether they tick them off or not.
Are they your laws or Chris Minz's
Point of
laws?
order. Point of order.
Yes.
Well, they're the government's laws,
I think
actually.
It's one question followed by the opportunity for the attorney to provide an answer. The compound question of any witness, particularly in this case the attorney who's answering the question, is unfair.
Thank you. To the point of order, I think the
Compound
Attorney
questions
General
are fair.
was managing. He was coping.
Well, I take the point of order, but I think that the attorney was doing quite well.
Thank you. Can we go back to the point about the empirical evidence that shows these laws are not effective, and if you were suggesting Cabinet thought otherwise?
The government decided to introduce these laws because we saw value in them, and after discussions with the police, we considered that they would bring a positive benefit to...
So can we just talk
New South
about
Wales.
that then, Attorney? What is that positive benefit again?
The positive benefit is that it enables the police to use other tools, in addition to those they've got, to detect people who, despite my urgings, have decided to walk out the door with a knife in their pocket.
And are you concerned that these new wanding powers will be disproportionately used against First Nations people, as we found out in Queensland and as we find with other discretionary police powers in New South Wales?
That's a matter for the police to use them.
They're your laws, Attorney General. It's your responsibility, is it not?
The police have the responsibility on the ground to use those laws.
Yes, but
as
you've
they
made
see
these
fit.
laws aware of these facts. These laws, discretionary police powers, which you're suggesting is the reason you've made these laws, to give police these discretionary powers, disproportionately impact First Nations people.
During discussions with the police before the laws were implemented, police assured all those concerned that they wouldn't use these on a discriminatory basis, and in addition to that, the government has convened an implementation group jointly chaired by the Secretary of the Premier's Department and the Commissioner for Police, with representatives from key government agencies and the Coalition of Aboriginal Peak Organisations. The purpose of the group would be to guide the development of operational procedures for the use of handheld metal scanners to align with the government's ongoing commitment to closing the gap.
So can you explain then how this will actually not disproportionately impact First Nations people on the ground? It's fine, you've got a force, a task force, a group, but how? So is the plan not to wand First Nations people? What's the plan? How is this actually going to take effect?
That's a question.
They're your laws, Attorney. They're yours.
The scanners are in the hands of police. That's a question for the police.
Will the Law Enforcement Conduct Commission be enlisted to review the development of the training materials in the exercise of these new powers?
I'm not sure I can take that on notice.
Thank you. I think it might be, and if you could, take on notice that if you haven't already enlisted them to do so, it is a wise idea to do so, and I think they would be very willing and able to do that.
I'm not sure that's within their charter, but as I said, I'll take it on notice.
I think if you, and I'm sure you're aware, the LECC have in fact offered to review the capacity and the implementation. Were you aware of that?
No.
Can I just ask you, Attorney, who did you consult with on your youth bail reforms?
Again, I'll take that on notice.
Thank you. And if you could take on notice whether you consulted with the Law Society, the Bar Association, the ALS, remembering that it was perhaps the most politically pointed
I did
statement.
consult with ALS and with some Aboriginal peak organisations, had a meeting with Carly Warner and others.
Yes, I think that was after they issued the most politically pointed statement I think they've ever made in the history of their existence.
Might well have been, but you asked me who I consulted with, and I've consulted with them.
Thank you. Did you see the Treasurer when he had to introduce those laws into the New South Wales Upper House?
No, I didn't, no.
Do you think that at this point in time it's good to introduce laws when you give this level of police powers and in the unprecedented bail reforms you've introduced against all advice of legal experts and community groups? Do you think it's wise to do that?
We've got a responsibility, Ms Higginson, to ensure community safety, and notwithstanding that sometimes there is advice to the contrary or laws might not be popular, governments have a responsibility to ensure that members of the community are safe, and that was the driving factor behind the introduction of those bail laws and performance crime laws.
And so you've also got a serious responsibility, and you a particular responsibility, in relation to closing the gap on First Nations incarceration. Commissioner Webb, as you would know, said officers are not responsible for closing the gap targets. And you and the Premier have both pushed for these new laws, the kind exactly that the Productivity Commission identified as directly worsening the gap in terms of incarceration outcomes. So what are you doing to close the gap, and how on First Nations incarceration?
I can tell you that those reforms were not made lightly, and they were... we approached cautiously.
Are these part of your tough?
Let me answer the question.
You're proud to be tough on laws?
This reform is not made lightly, and we approached them cautiously given the potentially serious consequences for young people, and particularly for Aboriginal young people. That's why the provision was carefully targeted to certain provisions of the Crimes Act only, and time limited for 12 months, with an evaluation to take place at the end of that period. But also keep in mind, Ms Higginson, which goes to the next second part of your question, is also part of a package of broader non-legislative initiatives aimed at reducing youth offending and supporting young people in their communities. And we do remain committed to working with communities and our Closing the Gap partners to develop long-term therapeutic and community-based approaches to address offending by young people on a broader scale. And we had these long discussions, good discussions, you and I, at this very forum last time we were in estimates about these sorts of
Can I
things.
just say, though, Attorney, there is a very strange and bizarre hypocrisy. You talk about how cautious, and yet there was no genuine consultation or engagement with the professional legal expert bodies in this state. You ignored the Bar Association, you ignored the Law Society, and really, I mean, it's an indictment, and I feel that there is a deep hypocrisy that you are speaking to the people of New South Wales right now. And let's face it, you know darn well that more young First Nations people are being incarcerated. What are you doing to close the gap?
Well, I do acknowledge that these laws have and will fall disproportionately on Aboriginal young people.
So what?
I do acknowledge that, but we have so the choice.
So what's more important?
The choice we had. So we had a situation in Moree, for example, where
These laws, Attorney, these laws apply to the whole of New South Wales.
That's right. But
you flew in some sports stars to Moree and you're locking up kids. Can you please explain how you're closing the gap?
No, I'll answer the first question first about why we did it. We had a situation where there were a small cohort of young people, not simply Aboriginal people, but young people in Moree and in other parts of the state that were breaking into people's houses, sometimes armed, often in company, filming those acts, to steal car keys, to then go driving around the state at night in packed cars with young unlicensed drivers with no seatbelts on, and we had to act quickly to ensure that someone wasn't hurt or killed during one of those home invasions, and that more carloads full of young kids didn't wrap themselves around a tree or collide with a truck or another vehicle. And so we've introduced these targeted measures to keep the community and these young people safe. The alternative was to do nothing and to let those kids continue to do what they were doing, and before long they were going to hurt themselves. And I understand a carload of kids did crash north of Moree with catastrophic consequences. I understand these laws weren't popular and that there was some opposition to it, but we didn't have a choice. We didn't have a choice.
That's just not true. That is just not true. You're the Attorney General of New South Wales. You always have a choice. You have a lot of choices. You have more choices than anyone in this state to deal with crime, to deal with bad behaviour, and this tough-on law that you don't apologise for. How's it going?
I don't accept
How's
that.
it going?
I don't accept that characterisation, by the way.
You're the one they're your words. Tough on laws and I don't apologise for them.
We're talking about the doubling the penalties for knife crime.
So you do
But we don't
apologise for
but we
these
don't- we
laws?
don't apologise
Are you
for the-
apologising to New South Wales for these awful, racist, draconian laws that are impacting First Nations young people?
I think that's a speech. Why don't you ask me a question?
I am asking you if you apologise for these laws.
No, we don't apologise for
Well,
these
you're
laws.
saying you had no choice. What is it? This is a predicament our state is in. There are people on their knees. There are people working in the courts, in the jail systems, around the clock, on the streets, and they're First Nations people.
Is there a question
They're
there?
on their knees. Do you
there a question
apologise
there?
to them for these laws? I ask the question.
And there are
Do you
also-
apologise to
there are
them for
also
these laws?
Many people, particularly older people in regional New South Wales, who feel unsafe in their homes. And also, I don't want kids wrapping themselves around a tree. At
Nobody
high speed,
does, Attorney.
Right?
Nobody does.
So that's.
Are these laws working for you?
So the first.
Because they're not working for First Nations kids, and they're not working
How
for
about
all
I
those
just sit
people
back
on the
and- I'll just
streets.
sit back and you just keep
Point of
going.
order,
Just
Chair.
make a speech.
Are the laws working for
Just
you?
give us a
Order.
lecture, so.
Thanks, Chair. I mean, the procedural fairness resolution requires that the witness is given time to answer a question when asked, and what's starting to creep in is just a series of questions, one on top of another, without a fair opportunity to
I'll
respond.
slow them down.
I'll uphold the point of order.
I'll slow them down.
The attorney must be given an opportunity to fairly answer the question before you staccato him again with another one. Please proceed.
So do you apologise for these laws?
No.
No. Okay, so you don't apologise for the fact that there are...
Asked and answered.
That's a bit rude, Greg.
No.
So you
Linda
don't...
can ask another question.
Thank you, Chair. So you don't apologise for the disproportionate impact and the further incarceration of young people in regional New South Wales who are First Nations children, young people?
I don't apologise for the introduction of those laws, and I've already explained why they were necessary.
Thank you.
Attorney, if I can just take you quickly back to your statements when we were speaking earlier, and I raised the delay in the implementation of Jack's Law and questioned public safety after the awful events of Bondi Junction, and you indicated, I believe, that Jack's Law was unrelated to the incident at Bondi Junction.
I'd have to go back and have a look at the Hansard to see what the exact context of those comments were.
I think all of us remember 20 minutes ago, and we heard you say that. Your press release of the 6th of June describes Jack's Law as essentially a response to tragic events we have witnessed in New South Wales recently. If it wasn't Bondi Junction,
No,
what other tragic events are you referring to?
I think you were suggesting to me that those laws might have prevented what happened in Bondi Junction. That was what my response was.
I am not suggesting that at all. I am suggesting
the
that the
context in
people
which I
of
was
New South
replying.
Wales are concerned about knife safety. Your first law failed, and Jack's Law will not be implemented till at least the end of next year. What are you doing about knife safety between now and the end of next year? New South Wales is worried.
The police have ample powers under the Summary Offences Act to deal with people now that they apprehend are carrying knives. They also run operations from time to time in various areas like train stations where they search people. So the police are out there working as hard as they can to keep the community safe, as you know. But that's really more a question for the police.
If you're so confident that police have ample powers, why was there any need for either of these pieces of legislation?
Because from time to time, governments consider that powers need to be improved and augmented.
Minister, you've increased penalties for knife crime and you've increased penalties for knife-related crime. You've done it twice in two separate pieces of legislation. You said the same thing essentially in two separate press releases a year apart. Why are you doing the same thing and expecting you'll get a different result?
I'm not sure I'd characterise it that way, doing the same thing. What does that mean?
Increasing penalties that are functionally unenforceable because they're in the district court rather than the local court, introducing a law that will not be operational for probably a good 18 months after you introduced it, and thinking that people will get a message from a press release rather than from actual enforcement on the ground.
There's plenty of enforcement on the ground. That's why you were quoting statistics to me earlier about how many people were charged and convicted.
The statistics I quoted to you, Attorney, about half an hour ago, were about those people dying from knife crime, which has increased 30% since you doubled the penalties. Anyway, thank you. I'll hand over to my colleague.
So are you saying your party doesn't support the knife crime laws that we brought to the Parliament that you voted for?
That's what I heard.
I'm saying what I'm looking for is implementation of your laws. And frankly, I am shocked that you do not have a start date for Jack's Law that was your legislation that you introduced. I ask you again, Mr Attorney, your law of June 2023, what's the start date for Jack's Law?
I've already answered that question.
You answered it that you don't know. So you introduce a law to protect the people of New South Wales.
The answer is...
We don't know when.
The answer is when the police are operationally ready.
And you, as Attorney General, are not driving that at all? It's not your responsibility?
Point of order, Chair. Chair, this situation is creeping in where we have yet again the honourable member, a different one this time, asking a series of rapid-fire questions towards the attorney as witness and not giving him an appropriate time to answer each question. And as a matter of fairness, he should be provided with time to answer the first question before he gets the second, third and fourth in a row.
To that point of order, If the Minister was providing an answer, I would have been delighted to hear it.
Tell him how to answer.
Well, I'll uphold the point of order. That's not really a response.
We might move on to another topic.
Questions? Yep.
Yes.
Thank you very much. Thank you, Attorney, and to everyone else for coming today. Attorney General, I might return to a couple of things that were raised at previous estimates. And you'll recall questions around BA and the King. And at the last estimates, which is on the 6th of March, page 44, if you needed to look it up, you responded when asked about BA and the King, that we discussed this at last estimates, which was, you were referring to the November estimates, and you went on to say, I reported then that the government would have some legislation to bring before the Parliament to address the implications of BA and the King. You then went on to say, it's important and something I want, is not something I want to delay.
Sorry, could you take me to the page you're talking about there?
Page 44,
Yeah,
from budget estimates, March this year.
gotcha, yep.
There's plenty of enforcement on the ground. That's why you were quoting.
The first section is obviously your answer to a previous question. And then my question is, we also discussed estimates BA and the King. I followed up with the Minister for Women and so on, and I've just quoted from you directly. You got that in front of you?
November 23. Anyway, keep going. Yep, I'll find it.
So my question is, where's that up to?
So last year I asked the Department of Communities and Justice to review all of the break and enter offences in Division 4 of Part 4 of the Crimes Act, which have sat without any significant review or update for nearly 20 years, and to carefully consider the serious issues raised by the High Court in BA and the King as part of that process. It's a complex area of law. Careful analysis is required. And so a consultation paper developed by DCJ was released to relevant stakeholders, including the domestic and family violence sector and legal stakeholders earlier this year. The consultation paper sought stakeholder reviews on reform to Part 4, Division 4. That consultation has now ended, and DCJ is working on a brief that will make recommendations for legislative reform, taking into account the issues raised by stakeholders, including important feedback from the domestic and family violence sector. We're doing this because we're serious about, as I said in the last estimates, protecting victim survivors from domestic and family violence, and we're working on this across government. In the context of the specific issue raised by BA and the King, there are, in addition, some protections for tenants experiencing domestic violence in the Residential Tenancies Act. Under Section 79 of that Act, a person's tenancy is automatically cancelled on the making of a final apprehended violence order that prohibits the person from having access to the premises. Under Section 105 capital B, a person has a right of early termination of a residential tenancy agreement in circumstances of public violence. New South Wales Fair Trading is conducting a review of those provisions and undertook consultation in late 2022. Further questions about the status of the review should be directed to the Minister for Better Regulation and Fair Trading. The New South Wales Government is also continuing our significant work to improve responses to domestic and family violence, including the passage of significant reforms to the bail framework and to better protect victim survivors of domestic violence. Landmark investment of $230 million over 4 years as part of an emergency package to enhance support for domestic, family and sexual violence victim survivors and expand programs that aim to reduce the rates of violence against women and children. This includes significant investment in early intervention and primary prevention, and I also stood up with the Premier and other ministers on Monday, Ms McLaren-Jones, and announced some further reforms in the domestic and family violence sector.
Thank you. So from what I gather from that, there is a couple of reviews that are being sort of fed in to you. So my question is, what is the time frame?
The time frame is mid-January to mid-January this year, commencement of targeted consultation. End of March, consultation closed. In July, DCJ brief the Attorney General with consultation outcomes. draft cabinet submission is being put together. Hopefully we'll go to cabinet in September, and then after that we'll be drafting a further targeted consultation on the draft bill and an introduction to Parliament early next year.
And what were the outcomes from that consultation?
I'd have to take that on notice.
Okay. Attorney General, on the 15th of May this year, you said our government is taking urgent action to address the unacceptable and persistently high rates of domestic violence in our state. That was when you were introducing the bail and other legislation domestic violence bill. Do you recall that?
I'm sure I made some comment like that. I don't know what you specifically quoted.
No, that's fine. So that was around 81 days ago. I'm interested to know what were the provisions of that bill?
Sorry, what?
What were the provisions of that bill? What was the specific details, the clauses, the section? What were the key things in the bill?
You can go back and look at my second reading speech and the bill, Madam Mr. McLean.
Do you know
we
what
made
was
changes to show cause, we made changes to the unacceptable risk, we added additional offences to the provision in relation to stays. There are others. It's all in the bill, it's all in the second reading speech.
But you can't name them?
I've just done it.
So they're the only things that you recall?
As in, I can get them, but yeah.
Yep, I'm happy to wait because I'm interested to know if all of those have been introduced. Or implemented, I should say.
There was also provisions in relation to electronic monitoring, things like that.
Yep. And when did the legislation commence?
So expanded the category of show cause offences to require, as I said, require alleged offenders to demonstrate why they should be out in the community. That test will now apply to serious domestic violence offences committed by intimate partners, including sexual assault, strangulation with intent to commit another offence, and kidnapping, with a maximum penalty of 14 years or more jail. It'll include the coercive control offence, which commenced on the 1st of July 2024. It'll require electronic monitoring of people charged with serious domestic violence from bail. That will mean that cohort will generally either be held on remand or electronically monitored. As I said, it expands the categories of offences for which bail decisions can be stayed. That is, the accused person remains in custody while prosecutors make a detention application to the Supreme Court. This will act as an additional safeguard to prevent the release of dangerous domestic violence offenders. And it made changes to the unacceptable risk test, requiring bail decision makers to consider, where relevant, domestic abuse risk factors, including red flags such as behaviour that's physically abusive or violent, behaviour that's sexually abusive, coercive or violent, behaviour that's stalking, behaviour that causes death or injury to an animal, behaviour that is verbally abusive, behaviour that's intimidating. We also take into account the views of victims and their family members where possible, about safety concerns for all domestic violence offences committed against an intimate partner. There'll be changes to make it easier to prosecute perpetrators who use tracking devices in a domestic violence context. We're also making changes to bail courts across New South Wales to ensure bail decisions are made by magistrates. For example, using audio-visual links. The show cause, stay, red flags, victim views and tracking device changes have all commenced. The government.
So that's commenced. What about the other items that you just listed?
All of them. I think the only one that hasn't commenced is the electronic monitoring.
So everything else
and that'll be the end of September.
Excuse me, there's a definite date for electronic monitoring, is there? End of September?
I can take in relation to electronic monitoring, electronic monitoring is the end of September. Sorry.
It is the end of September?
Yes.
It will be introduced?
That is the proposal, yes.
No. So we're talking about 28 days
There's an
that will be in
implementation
place.
task force here that's been looking at this.
The electronic monitoring will commence very shortly. We're expecting early October.
But you don't have a date, so it's end of September, it's early October.
very
Is there a
imminent.
definite date for electronic
There's
monitoring?
not a definite date, but it's, we hope it will be around October sometime, yep.
So we have an October hope for the introduction of electronic monitoring.
Expectation.
Thank you.
Just on electronic monitoring, how much money has been allocated in the budget for that
I
implementation?
have to take that on notice.
Has funds been allocated in the budget?
It's well, I'll take it on notice because I want to be accurate about that.
Okay. I might move on regarding the imprisonment. How many people, how many prisoners are on remand or currently?
Mr. Tidball will have that at his fingertips. I
Yes,
think.
as of this morning, there are 13,009 adult prisoners in the New South Wales correction system. 56% of those are sentenced prisoners and 43% are held on remand.
Mm-hmm. And do you have a figure of maybe the 30th of June this year or earlier?
I would. Can I come back with that through the day? I certainly will have it this afternoon. I'll have it on me. I just sent to go
Yeah, I
search.
think Boxar published those, but I don't have them with me.
And Mr. Tidball, do you have a figure for those people on remand who are on remand as a result of the changes introduced in this legislation?
No, I don't.
I don't think they're available
Okay.
yet through Boxar, but we could get them through other avenues.
Yeah, because we would be very interested in essentially a metric of the success of these laws, the rise in prisoners on demand, on remand as a result of the introduction of these TV bail laws. Thank you.
Well, it's up to him. You do what you
Attorney General, what is the cost of increased remand time under this legislation?
The cost, I don't know if those figures would be available. If they were, they'd be in Mr. Chanthevong's bailiwick, not mine.
Do you know if that's being looked at?
That's a question for Minister Chanthevong.
Okay.
They're corrections costs.
Yep. Have you had any discussions with the Minister for Corrections in relation to the budget?
In relation to the budget?
Oh, in relation to the implementation of...
Informally, yes.
And, but you didn't discuss the amount that would be required to implement those laws?
No.
No, you didn't? Okay.
Not that I can... I mean, there are cabinet processes about that and discussions we had in the cabinet context, but I can't obviously share them.
So just back
Sorry,
to...
Mr. Tidball
Sorry.
might be able to assist.
If I can just indicate that the Minister for Corrections obviously can deal with these matters in his estimates, but the Commissioner and I, for Corrective Services, and I regularly touch base on projections in terms of sentencing and remand. Those figures with close reference to Boxar figures are recalibrated according to law reform, and those numbers are, we do project the numbers, and there is capacity in the system.
Mm-hmm. So just back to electronic monitoring, I understand that you don't have the figures of how much has been allocated in the budget for that. Do you know how many electronic monitoring devices will be available?
That's not being led by DCJ. I think it's been led, but there's an implementation task force, but it's been driven through premiers, isn't it?
There is, yes, but there'll be corrective services
but they'll
devices.
be corrections do electronic monitoring. They'll be the ones who do that, supervising that, purchasing the equipment, all that sorts of things.
So who are the members of the implementation task force?
Is that right? There is an implementation task force, or is it just a group led by premiers? Yes.
There's an implementation task force led by the Cabinet Office.
Cabinet Office, sorry.
Led by the Cabinet Office, and the members are?
It includes membership from all the government agencies that are affected by
Which are?
electronic monitoring. Off the top of my head, the areas, the policy areas that deal with it, corrections, police, legal aid are on the task force. There will be other members too.
Is AG's on the task force?
What is AG's?
Attorney General?
I'm on the task force.
Right, representing...
The department.
The Department of Communities and Justice.
Okay.
Yeah.
And who else is on the task force representing DCJ or any other departments?
The Commissioner for Corrective Services.
Yep.
Mr.
I'm also on that task force.
Okay. On notice, could we have a list of the membership of the task force?
Yes.
And how often do they meet?
Very regularly.
What, daily, weekly, monthly?
It is. I would have to take that on notice. It is very frequent.
If you could take it on notice, please. And what's the budget that you're looking at for the implementation of electronic monitoring?
I would have to take that on notice.
Thank you.
And just one final question. Which minister is ultimately responsible for the implementation? Is it the Premier or the Attorney General who has ultimate oversight of this task force and drives it?
It's been led through the Cabinet Office.
So the Premier is responsible for this task force?
Look, it's been led through the Cabinet Office, but the legislation is mine.
Yep, so you're ultimately responsible for the task force?
I'm responsible for the legislation, and then government departments go away and put the machinery provisions together to make it work.
But I'm just trying to ascertain, ultimately someone in government has to be responsible for this task force and have the reporting done to them, and is that the Premier or yourself?
Probably the Minister for Corrections in relation to the electronic monitoring.
Okay, so it's a... Thank you.
Ms Mahalik?
Thank you, Chair.
Good morning, Ms Mahalik.
Good morning, Attorney General. I just want to start with asking you about these horrific charges on the former member for Pittwater, Rory Amon. That's 10 child sexual assault charges. Now, I appreciate that you may not be able to answer all my questions, but I do want to put them. I wanted to just start by asking, I understand the Minister for Police indicated that she had no knowledge of it. I suspect that's the same with yourself. Prior to the charges, prior to the day that the charges became public, you had no knowledge, Attorney General?
None.
None whatsoever. I wanted to ask the processes, and it may be that that you might seek advice on this or take it on notice, but the Strike Force Neural, it appears that the investigation, from what we reported, started in June of 2022, and in March 23, a Strike Force Neural, if I'm got the word right, was established, and it then took 17 months for this person to be charged. And I'm trying to understand why, Attorney General, was there such a length of time of 17 months before this person was charged with what seems to be very horrific charges, 10 child sexual assault charges, including 5 counts of sexual intercourse with a child under the age of 14. That's 17 months that this member of Parliament went around to community events, went around to school events, went around to sporting events. There are parents now absolutely outraged that they had any interactions with this person or that their child had interactions with this person. What I want to put to you, is it very likely that this individual would have been notified prior to the charges being laid that he was under investigation and there was such a strike force?
I have no knowledge of any of those matters. They sit fairly and squarely, not even with the Minister for Police. They sit within operational police. So I have no knowledge of any of those aspects that you're asking me
When
about.
does the DPP get involved?
After charges are laid and a brief has been presented, the director's sitting there, but when the police serve a brief on the DPP, they take over the prosecution because it's they're indictable offences.
When does that happen?
The Director of Public
In this case,
Prosecution.
yes, I'll ask the DPP.
Charges are laid by police. They proceed for a period of time in the local court under the carriage of police, and then the brief is handed to DPP. Depending on the complexity of the brief, usually within about 12 weeks of charges being laid, and then carriage of the matter remains with my office.
Okay, thank you. What I want to ask you, Attorney General, because this is such a these are such horrific charges, and the person was in public office, and I think many people are asking the question, how could an investigation take so long? How could the strike force take so long? And how is it that Attorney General's not notified, the police minister's not notified, nobody in Parliament's notified that there was even a strike force established, and this person was able to continue interacting with the children and young people and families across his electorate?
I really don't feel comfortable as Attorney General engaging in commentary about this. This is before the courts. It's not.
I understand that.
It's not appropriate.
I understand that. Are there? I mean, there's pretty strong penalties, obviously, for such charges. Would the government ever consider, for people in public office, having stronger penalties? I mean, the point to me is somebody in public office, there should be, a higher threshold of what they. Would the government ever consider looking at that? Because I think there are people asking the question, yes, he's going to be charged, he may end up being convicted, but, there's a real expectation that people are honourable when they're members of Parliament. I think this has been a very difficult thing for the community to accept because it's so horrific, and I don't think it should be swept under the carpet. I know it suits some that's the case, but is there ever a consideration that people in public office should be held to a higher standard, Attorney General?
I think we already are held to a higher standard in many regards. Look, you're asking me to speculate about what the government might do, and in the context of those charges, as I indicated, I don't feel comfortable.
No.
In
That's fine. I'll move on to a couple of other issues that I wanted to raise this morning, Attorney General. I wanted to ask you for an update on how we're going with the anti-discrimination Act review that's being undertaken by the Law Reform Commission. Have you had any updates?
It's with the Law Reform Commission. I can't put a time frame on when they might get that back to me, but I anticipate it'll be either late this year or perhaps early next year. But I can't hurry that committee up.
They had preliminary submissions were due and finalised at September 23.
Yep.
So they've now indicated they're preparing a consultation paper.
Yep.
They haven't indicated to you or your office when that consultation paper will be released?
Preliminary submissions to the review close on 29th, 92 published on the website.
Yes.
The Commission's currently reviewing these and expects to release a consultation paper in the coming months.
That's off the website. I've read the same thing.
Okay, so no, the answer is no.
But I've read the exact same thing.
And
it's
I
on the
don't
website.
really want to hurry them. I mean, we've got one of the most eminent lawyers in Australian legal history, Tom Bathurst, heading that commission up. And,
I'm just asking whether he's notified your office to advise when this consultation paper is
no,
coming
as a
out.
matter of convention, they don't do that. They don't
Okay.
give time frames for that.
What about the fact that you've got an equality bill also before Parliament right now that's proposing 52 amendments to the ADA Act review, and apparently that's now going to be considered, in October? Is that
I don't
right?
know when. That's a matter for government.
Well, you're in government.
Yeah.
Okay.
Crosses a great many portfolios. Government has not made a decision.
Will you be
on
the
it.
person charged in the Labor Party to have carriage over it?
I
or-
expect so.
Yes, I expect so too.
Yeah.
Okay. But there'll be 52 amendments to the ADA Act that are being proposed in that bit of legislation. And there's a review in the ADA Act at the same time.
Yep.
So why would the government even consider this legislation if they haven't even got a consultation paper out on the ADA Act?
Well, as I say, we'll have a look at all those considerations and
Minister, have you
make
had
our
a
mind
look
up
at what
in October.
Queensland government's introduced this year in June in respect to the ADA Act?
No, I haven't.
Okay. They also undertook, you understand, a 3-year review with the Human Rights Commission
Yep.
of Queensland. Are you familiar with the report that
No,
was
I'm not, no.
published in regards to that?
No.
No? And you're not familiar with the draft bill that the Human Rights Commission originally proposed? ADA Act
Queensland? No.
No, okay. It was then, they produced their own draft bill, and the government, the Queensland government, then rewrote it and rebranded it and essentially took out the more controversial parts. Can I just ask, are you expecting the Law Reform Commission to draft a bill in this process, or similarly to what happened in Queensland?
I don't think so. I think that the Law Reform Commission will just release its report with recommendations, and the government will then have to take into consideration what those recommendations are.
And draft its own bill. Is that what you're suggesting?
Bill, yes.
Draft its own bill. Okay, so they'll draft its own.
And we will, when we get to that point, because there will be amendments to the Act. The Act is a 1977 Act that was due for statutory review a decade ago and was ignored. It's not fit for purpose. I've said that before, and there
Why is it not fit for purpose?
Oh, because, well, let me just give you some examples. So, there are, as I see, about 11 protected attributes.
Yes.
So, when you're talking about racial discrimination,
Yep.
Race is protected in terms of discrimination and vilification. Then you've got provisions around sexual harassment that were dropped in that sit by themselves. Then you've got sexual discrimination but no vilification on the ground of sex. On transgender status, you've got discrimination and vilification. On the status of being married or in a domestic relationship, discrimination but no vilification. Disability, discrimination is protected but not vilification. Things like that. So there are inconsistencies right through the Act, and it's just not fit for purpose now. So there will be amendments to it. I can't say what they will be, what the Act will look like, but I just want to give an assurance to the public that we will consult very, very widely.
What about the
on
exemptions
those.
for religious institutions?
I'm sure Mr. Bathurst and the committee will look at those in great detail.
I'll come back.
Thank you. Attorney, I just want to go back to closing the gap if I can. Based on the current rate of incarceration of First Nations young people, when will your government meet the closing the gap target 10 and reduce the rate of Aboriginal and Torres Strait Islander adults held in incarceration by at least 15%?
If you're asking me to predict when we might do that or otherwise, I can't give you any dates about that.
No, I'm asking when your government's planning to do that. What is your forecast? You're committed to this, surely. So what is the plan?
What you're saying, there's a set date upon which we might...
Surely there's a prospective time frame, how long you're going to take to get to there.
The agreement, the national agreement around closing the gap determines that by a certain date, states and jurisdictions will have reduced rates by a certain amount.
And when is that for this gap target 10?
I don't have the...
20, if I can assist.
Thank you.
I'm stating the obvious. 2031 was obviously the target. We are 45 young people, or very close to that figure, above that as 45 above that as of June 2023, and we have been close. The gap has increased recently.
Is there? Do you have? So why is that, Attorney? Does that concern you that the gap's increased? And can you make yet any correlation on how many children have been refused bail or prosecuted under the new laws as well?
I can get you all of those.
Part of the trick is, Ms. Dickinson, it is, and I want to say this with sensitivity, but it is a sensitive figure. There are 231 young people in custody as of today. And they are all important lives, I acknowledge, but the figure, because it is that number, is way more sensitive than, say, in the adult prison system.
Sorry, so there's 231 people in custody now?
Correct.
Yep. And what was that part, sorry, about the figure being...
Well, it's just, clearly, if you've got 231,000 as compared with an adult population of 13,000.
Yes.
This figure is highly sensitive to movements.
I see. Thank
in
you.
percentage
Sorry.
terms.
Yeah. So, so we don't. Do you know, Attorney, whether the figures at the moment have any reflection on your new targeted laws that will lead to more young First Nations children being incarcerated?
I don't have those figures, but I'm readily
You'll
concede.
take that on.
No, I'll concede, Ms. Higginson, that they will result in a disproportionate number of Aboriginal young people being incarcerated and held on remand and arrested, and they will reflect negatively on our closing the gap targets. At the moment, targets 10 and 11 are not on track, and they're worsening. So that's why the initiatives that we are undertaking, things like the expansion of circle sentencing, where we've expanded circle sentencing from 12 to 22 local courts in higher priority locations, which deals with, which will provide access to circle sentencing for up to 2,100 additional Aboriginal offenders are important.
Can you see? Sorry, excuse me, Attorney Jack. Can you see the hypocrisy? What does that do? That's after the event. That's after the fact. That is, really, I think, don't even try at this point. You've just provided evidence that you are worsening the gap. Earlier today, you provided evidence that you're unashamedly tough on crime and that this is the consequence. Oh, sorry, I'm mixing it up between the knifing and the bail laws. Apologies. So, Attorney, I think there is a point where it is really important to accept that a tough on crime, a law and order agenda doesn't actually work, and what it does is causes really significant harm to the most vulnerable people in our communities. Would you not agree?
I don't like that expression, tough on crime. We're appropriate on criminal, right? I don't use that expression, that we're tough on crime. I don't like it. It's not appropriate.
You said, Attorney, you don't apologise for the bail laws.
For introducing
No, you
tough
said you
knife
don't
laws.
apologise for the bail reforms.
Yeah.
So unapologetically, you are sitting here saying you are not closing the gap, you are worsening the gap, and you are widening the gap for First Nations young people in this state of New South Wales. Surely that is shameful. Surely.
Is that a question?
I'm asking, surely it is. Is it not?
That's not a question.
So you don't think it's shameful?
We are. Our job is to keep communities safe.
No, your job is to close the gap. You just said that. And you're saying you're not doing that. You're going the opposite direction. What do we do as a committee? How do we take that evidence? We just sit here and say it's fine that the state is not only not closing the gap, it's widening the gap in what is identified as one of the worst impacts on First Nations communities. Young people incarcerated in regional New South Wales. Young First Nations children. Is it shameful? Do you apologise?
Don't ask me questions like that. That's not a question seeking information.
It's a lecture.
Yeah, it's a good
seeking.
speech, but
It
no.
is seeking from the Attorney General, the highest law officer in this state, a position on the state of the law closing the gap and First Nations justice, particularly young people in this state.
Point of order, Chair. Point of order, Chair.
It is a question. I'm just asking for your answer.
There's no question there.
Point of order, Chair. While I think we all feel very deeply about these issues, and the Attorney General has indicated that yes, we do, Ms. Higginson, there is a level now of rhetorical questioning that's not even requiring answer. They're not questions appropriate for budget estimates in terms of how they're being framed, and I'm sure the Attorney will answer the appropriate questions as he has about the figures with regards to closing the gap.
Well, rhetorical questions are acceptable.
Yeah,
So
there's no
just
point
in
of
response,
in
response to that.
That's another issue.
Okay, I'll move on to another question.
Sorry, you just had
I'll
a
move
2
on
minute
to another question.
You just had a 2 minute question.
I'll move on to another question.
No, you won't, because
it's my job to ask the questions, Attorney.
So you've just had a diatribe, and I didn't interrupt you.
I didn't
so now-
diatribe.
So
is that what it is?
Let me tell you.
It's diatribe,
Let me
is
tell
it, Attorney?
you what we are doing.
Not closing the gap is
Let me tell you what we are
diatribe.
doing to address criminal behaviour. The New South Wales Government's committed a total funding of package of $10 million over 4 years to expand justice reinvestment in New South Wales. The Paul Ramsay Foundation are also contributing $9.4 million towards advancing justice reinvestment in New South Wales, specifically in Kempsey, Nowra, the existing sites of Burke, Mount Druitt and Moree. In January of this year, DCJ launched the New South Wales Justice Reinvestment Grant Program to expend $7 million of this funding package from June 22 to June 27, and there were successful recipients there. The New South Wales Justice Reinvestment Grant Program prioritised 3-year proposals led by Aboriginal and or Torres Strait Islander community-controlled organisations that develop local solutions to curb the high rates of adults and young people in contact with the police. In June 23, DCJ entered into a contract.
Point of order. Sorry, can I excuse you now? Thank you, Attorney General. I didn't ask you the question, but thank you anyway.
but when you...
No, I feel you've had a long time now. Can I move on, please? Thank you.
So you're suggesting that we were doing nothing in relation to helping young people, young Aboriginal people?
No, I didn't suggest that at all. I suggested that you've widened the gap, you're not closing it, and you are incarcerating more young First Nations children across the state. And I asked you whether you're proud of that or it's shameful.
And I readily conceded that to you without you having to prompt me.
Attorney, in the last 40 seconds, could you please tell me how the ex gratia payment is going to Kathleen Folbig at this point? How are you going with that and the decision?
So I understand that correct me if I'm wrong here, on the 27th of July, Ms Folbig's legal representatives wrote directly to DCJ Legal seeking an ex gratia payment, and DCJ is now preparing a response for me in order to consider what we do with that application.
And will that be, will you commit to having it finalised before the end of this year?
I'm not going to commit to anything because I haven't been in this position before. I don't know that we've had such a high profile case that's as Ms Folbig seeking an ex gratia payment. So I want to make sure that we get this absolutely right, and it won't be based on my opinions in relation to anything. It'll be based on expert, detailed legal advice.
But just in terms of the timing,
I can't give you.
Well, will you commit to?
What I will commit to is no delay.
Thank you.
On the part of the department or me. I understand there's serious ramifications here, all round. No delay.
Thank you.
Opposition, the last couple of minutes.
Thank you. If I can just go back to the implementation committee for the electronic monitoring. Once it's up and running, who will be running the electronic monitoring?
Who will be running it? Corrections will be.
Corrections.
Yeah.
Can you give me another example of when corrections will be handling a program for people, none of whom have yet been convicted of anything?
There isn't one in New South Wales. That's part of the problem. That's where we're starting.
So why is the choice to have corrections running it?
Because corrections do a really good job with post-parole and post-conviction offenders.
Yes, and so now they'll be dealing with pre-conviction people who may possibly not even be offenders?
Correct.
Why is this a corrections matter?
Because they have the expertise in running electronic monitoring.
And that can't be shared with somebody else, another department or another operating group who would be more appropriate to deal with people who are not prisoners?
No, they have the expertise within that department, and it's prudent to draw on that expertise, I would have thought.
So I understand that corrections also have expertise dealing with programs that get people into work. Should they be handling all the government programs getting people into work?
No.
Well, why should they be dealing with this and not that if it's a question of expertise?
I don't know that I can answer your question more effectively than I have.
Okay, is there a systemic issue with saying that a corrections whose only job is to deal with people who have been convicted of an offence should now be asked to deal with people who may not ever be guilty of an offence? You see no problem with that?
I don't know that you're characterising it correctly. Corrections have a division within their department that deals with the electronic monitoring of people who are on parole.
Yes. And what's the difference between parole and bail, Mr. Attorney?
One is pre-conviction, one's post-conviction, obviously.
Exactly my point. Exactly my point.
Yeah. So what do you want us to build from scratch? A whole new department within police, or?
I worry about people who are on bail being seen to be handled by corrections, and the message that might
corrections
send
hold
to the
people on
community.
remand now.
Sorry?
Corrections deal with the security of people who are on remand already.
So you think, all right, so it's essential remand. All right, thank you.
56% of the prison population's on remand. They're looked after by corrections
Yeah, no,
now.
thank you.
Okay, at this point, we'll go to government questions.
We've no questions.
You've got no questions?
Why?
What a
Come
surprise.
Come on, Cameron.
Oh, buddy.
And we're not going to give any lectures either. No
Greg's
lectures.
got a few questions.
Do what Mick
Jonathan
Veitch used to
put
do and just throw me one anyway that wasn't on the agenda.
All right, there being no government contribution, apart from the Attorney General, we'll now break until 11:15. Thank you.
Thank you, Chair.
on.
Might get started again, please. It's now 11:15. And we'll go to opposition questions.
Great. Thank you very much. Minister, part of your reforms that we were discussing just prior to the break in relation to domestic violence included a commitment that bail decisions would be made by magistrates, not registrars. Is this in place now?
It's getting there. Money's been allocated for upgrades to AVLs, and it's on the way. Mr. Tibble will have precise timetable for you.
Yeah, so in terms of the timetable, given the nature of the provision, i.e. needing to have the capacity for registrars to effectively be able to process across the state, the $4 million...
Excuse me, registrars or magistrates?
Sorry, registrars. Matters being heard only by magistrates, not by registrars. There's a process working right across the state. I've had discussions with, my most recent discussion with the Police Commissioner last week about effectively mapping the state so that we stand up that AVL, which has been funded, whether it be in a police station or a court, does not matter. The thing that matters is that the state is covered. There's a $4 million allocation for that AVL, and the work is progressing. The plan is to turn that provision on when everything is in place, and that's expected to be by the end of calendar 2024.
So the expectation is that that legislation will commence at the end of December 2024?
Legislation's commenced, the provision will be operational by...
particular provision
Excuse me, Mr Attorney General, have all of the provisions of the legislation commenced?
I'd have to go through...
That provision has...
Show cause has...
You don't know that?
Show cause has electronic monitoring...
You don't know when your legislation commences?
Don't interrupt me, ask me a question.
Point of order.
Show cause has, I've already answered that.
Order.
Electronic monitoring was spoken about.
Point of order.
State...
Excuse me, Mr Attorney...
Sorry, my point of order was it's quite disrespectful for the honourable member to interrupt the attorney when he's actually answering the question. And she should be called to order and allow the attorney to actually continue with his answer.
I don't think it quite makes the threshold for being called to order compared to what I've seen in these estimates in the past. But I uphold the call to order, except that part.
So the answer is, Ms Carr, everything except electronic monitoring and registrars has been introduced, and we've answered the timetable in respect of both of those this morning.
Yeah. So just to confirm, electronic monitoring has not commenced, magistrates have not commenced yet?
No, that's right.
Is there a commencement date for electronic monitoring?
I think we've gone through that already this morning.
No, commencement date for the legislation. You've talked about implementation. Is there a commencement date for the legislation?
That was the answer I gave you this morning.
So, sorry, what is the commencement date for the legislation?
So that we expect electronic monitoring to be in place in early October.
So that's the implementation. When will the legislation commence?
1st of July.
So sometime in
answer.
early October, we don't know when.
That's right.
And the magistrates, the commencement date for that is?
As I've said, the provision will be turned on commenced when the registrar matter is dealt with, and we're working through that. We're working through that quickly. We're working through it in lockstep with the police, but it is about standing up AVL, making sure that we have a network of capability in place. It will be by the end of the year. I cannot give you a specific date other than by the end of calendar 2024.
Right. Okay, thank you very much. And in the gender equality statement, Attorney General, page 41...
Sorry, I missed it. Sorry.
Sorry, the gender equality statement of the budget, at page 41, you say that up to 6 additional magistrates will be employed as part of the response to domestic violence. Have they been appointed yet?
I have to get some advice on that. I'll take that on notice.
Take that on notice, okay. Is there appointment to reduce existing delays in hearing domestic violence matters, or are they specifically for bail matters?
Sorry, I don't understand the question.
So you state that there will be up to 6 additional magistrates employed. Are they to reduce delays in domestic violence matters? Are they for bail? What is the purpose of those 6 magistrates?
They were as part of the bail package, I think, weren't they?
There'll be general magistrates doing all duties.
Okay, I might just hand you over to Chris Death.
There'll be general magistrates employed in the local court responsible for all the duties of a magistrate.
Okay. And so they will assist with reduction in delays?
They'll assist in all areas of the local court.
Okay, and they will be in which courts?
I don't have the details of the
wherever.
location of the magistrates is a matter for the chief magistrate.
Thank you very much. And their salary, is that to be paid for as part of the $45 million package to improve bail laws and the justice system, or does that come from a different fund?
I'm not sure.
There's a combination.
Let's take that on notice.
Yeah.
Take that on notice. Perhaps you could also take on notice whether that funding is one-off or whether they will continue to be employed in coming years.
Sure.
The gender equality statement says up to 6. Does this mean that you may employ less than 6?
At the moment, the target is 6, I think, and
Okay. Is there a guarantee that there will be 6, or that's an aspirational target?
I think the applications, expressions of interest closed recently for additional magistrates, and there'll be a process to go through in relation to those applications. There'll be a matter then for the attorney in terms of how many appointments are made from that.
And I guess that's what I'm asking. What is the attorney's current intention as to how many magistrates will be employed?
I'll just take that on notice so I'll give you a completely accurate answer.
Okay, so you can't share your current intention. Thank you. And can you explain something to me about how the new centralised bail court is going to work?
So what will happen is, at the moment, on weekends, in some courts, magistrates will come in on the weekends, but mostly they're done by registrars. We've made a commitment that no bail hearings will be heard by registrars. And so on the weekend, there will be a centralised bail court at Parramatta, where there will be, I think, 6 acting magistrates on duty to hear all bail matters. The ones from outside of Parramatta, where it's not feasible to transport the offender to Parramatta, they'll be heard via AVL from the venue that they are at.
And that's funded as part of the $230 million domestic violence package?
No, it's funded as part of the $45 million package.
That's out of the $45 million
Yep.
package, thank you. And of the $45 million, what's the estimated cost of that centralised bail court?
I have to get you the updated figures on that, so I'll take that on notice.
Yeah, if you could, that would be good. And just in relation to the audiovisual link facilities and the centralised bail court, if we look at budget paper number 3 at 211, it indicates that the total cost of this will be $18 million, but currently, until the end of 2028, there's only $14.1 million allocated. Does this mean that the budget suggests that this will actually roll out past December and actually take more than 4 years to actually implement?
No, it won't.
Then how do you explain the budget figures?
I'll take that on notice. But
All
no,
right,
it
thank
won't.
you.
I think that budget might have predated those announcements, I think.
So the budget predated the announcement, so the budget figures are wrong?
I'll take it on notice.
Great,
Yeah.
thank you very much.
Thank you, Attorney General. In the budget statement, the gender equality statement, page 41, it states the New South Wales Government has passed new laws to strengthen community safety by making it harder for alleged serious domestic violence offenders to get bail and ensure that all bail decisions are made by magistrates and judges. Today in the Daily Telegraph, there was an article regarding a man, Kamal El Jamal, who has been charged with shooting his wife and severing her spine. And it states that he's been granted bail yet again while he awaits trial, this time after he allegedly drove at a security guard while trying to flee the rehabilitations facility. The Attorney General, do you think your new bail laws are currently working?
I don't want to comment on that specific matter because it's currently before the courts, and I have great reluctance in talking about individual matters anyway.
Point of
but
order.
that one's before the court.
Point of order.
I understand the Attorney General's reluctance to discuss matters before the court. The question did not ask the Attorney to discuss a matter before the court. The question gave an example and asked the Attorney to reflect on whether the new laws were actually working.
Well, to the point of order, I mean, that's just not right, in that the entire characterisation and framing of the question was specifically about a case that's before the courts, and it would be completely inappropriate for the attorney to answer a question framed in that way.
Would you like to frame the question again?
Attorney General, do you think your current bail laws are working?
Well,
and do you have examples of where they are?
Well, it's a bit early to tell because they came in on the 1st of July. So we will see what will happen to the remand figures. I suppose one of the measures will be whether there are more serious offenders who are remanded due to not being able to get bail as a result of our new laws. They only came in on the 1st of July, so it's a bit early to tell. So.
And will you be monitoring those remand figures, or is that your
No,
responsibility?
I'll be monitoring them carefully.
And how often will you be checking? Is it something 6 monthly, monthly, 12 monthly?
It might be weekly. I meet with these senior officers weekly, and remand figures are of great concern, and I may even be asking them on a weekly basis.
So we're now 2 months in.
And talking to Minister Chanthibong as well.
Thank you. We're now 2 months in. Have you asked for any of those figures to date?
I've spoken to the officers about that, and the remand figures, the figures that I'm getting show that the remand population is on the increase. But I need to then make the necessary connection between those figures and these provisions.
Okay.
It's possible, Ms McLaren-Jones, and if, anecdotally I've been told that following the alleged murder of Molly Ticehurst, there was already behavioural change in the judiciary where magistrates and judges were refusing bail more often in relation to sexual assault and domestic violence matters than they might have been previously. But I don't have any figures to back that up. That's just my conversations with judicial officers.
And when you're looking at those figures and also being able to then obviously do a breakdown as to whether or not the bail laws are effective, will you be releasing that data publicly?
Yeah, sure.
Thank you. I might move...
I think Boxer will do that. Anyway.
Yes, I also receive a weekly update on remand figures with some breakdown from the Corrective Services Commissioner, which I monitor very closely.
Thank you. Attorney General, I might move to the Hunter Valley bus crash and a question that you were asked on the 8th of May in the Parliament. You stated at the time that you had asked the DPP for a comprehensive briefing on all aspects of this matter when it's finally concluded, unquote. Did you receive that briefing?
No, I think if you I don't have those Hansard comments in front of me, and I'm very reluctant to talk about this because it's before the courts. In fact, I think the sentencing hearing is on next week. I think what I did say at the time was, having met with some of the grieving fathers from that accident, and that was a really difficult meeting, I have to tell you, given the pain that those people are feeling. I said I didn't want. I was disappointed when any victims or families of victims feel hurt or traumatised or let down by the justice system. But the matter was before the courts. The DPP is an independent statutory office holder. But when the matter is finally dealt with, I'd be asking the DPP to brief me on what happened in the lead up to the prosecution, her dealings with the families and things like that. So once it's done, then I'll be sitting down with the DPP to see if we can assist her and her office to improve those processes of talking to affected people if we deem that those improvements are necessary.
So you haven't had a meeting or a briefing from the DPP?
Not in respect of those comments, because I'm waiting for the matter to be concluded.
Okay.
I think I've got that right, haven't I, Director? Yeah?
Yeah, I've got a copy here of your of Hansard, and you
Yeah.
have said the aspects of the matter when it's finally concluded.
Yeah.
Would you comment on whether or not you think the DPP has handled this matter appropriately?
No, not before, it's before the courts.
Mhm.
No.
Do you know when the matter will be concluded and you intend to speak to the DPP?
My understanding is that the sentencing hearing is on in Newcastle Court next week, and it's set down for 3 days. Beyond that, I don't know.
Okay.
It might well be that the judge will take submissions over 3 days and reserve decision, or whether hand it down straight away. Don't know.
I understand, based on media reports and also from Hansard, that you did speak to some of the family members, and I would like to know your opinion or your view in relation to how the DPP does communicate with victims and what improvements can be made.
I think I just probably answered that question.
Here's what I found. So he's always very busy.
That's Siri butting in.
She's very busy in estimates,
Yeah.
always butting in. All right, thank you very much. I might move on to graffiti in particular, Attorney General. Now, do you prescribe to the broken windows theory?
I'm not sure what the broken window series is. Is that if someone breaks a window or graffiti something, you fix it up straight away to
Yeah,
deprive
visible
them of their
signs
artistic
of crime.
exhibition, isn't it? Yeah, probably. Yeah.
Yeah?
I think there's some currency in that, yes.
Then can you explain why you've chosen to cut Crime Prevention Fund and also the Graffiti Initiative Fund in the last budget?
I'll have to take that on notice.
But aren't these line items in your budget or have been previously
Yeah,
in?
I'll take it on notice.
But why did you choose to cut them?
I just said I'll take it on notice.
But you made the decision to cut.
Point of order,
I can't be any more specific than that I'll take it on
Point of
notice.
order, Chair.
Point of order.
Witnesses, including the AG, are entitled to take things on notice in order to get correct information, and Ms McLaren-Jones has asked the same question, I think, 4, possibly 5 times. The Minister said he'll take it on notice.
To the point of order, I'm asking why he's made a decision. Clearly he would know why he decides things.
My answer is that I'll take it on notice.
Okay, that's the answer. Thank you.
Attorney General, did you actually make the decision or did someone make it for you?
I'll take it on notice. The budget is a government document that goes through cabinet. So
But Attorney General, this is a fund that, or 2 funds that were administered by the Attorney General, and you're saying that you didn't know that they were being cut?
I think, if you're asking me to rely on memory, that they were programs that were funded by the previous government for
Probably
4 years
fiscal
only.
cliff,
That I will take that on notice.
Attorney General, it's been put that the $13 billion, and I'll happily quote. So an email was sent by the Crime Prevention's email advising that a decision follows the comprehensive expenditure review announcement by the New South Wales Government in June 2023, which resulted in the inclusion of a $13 billion in saving, prioritisation and other budget improvement measures in the state budget over the next 4 years. And they went on to say, we recognise this decision will be disappointing for many. Attorney General, can you outline what is more important as a priority than funding crime prevention in the local communities?
So I didn't get the first part of your question.
Attorney General, I was referring to the 2 grants that have been defunded.
The ones you just asked me about that I've sort of taken on notice, right?
And your department advised the local community that they were being cut because of expenditure review decision. And I'm asking you, what is a priority? What is a higher priority than funding graffiti removal?
Why didn't you put funding in the budget?
What is more important than funding graffiti removal?
So you're asking me about the context about which those programs were discontinued, and I've said I'll have to go back and take that on notice. It might well be that they weren't valued for money, that they didn't work, that they were evaluated as not being, there were better ways to do it. I don't know. That's why I said I'd take it on notice.
And I'm asking you, what is more important than funding programs like that? What has replaced it?
I'll take it on notice. It might be that they weren't replaced. I don't know. That's why I said I'll take it on notice. You asked me about a budget from over a year ago, so I'll have a look and get back to you.
But this is budget estimates. Surely you know what you're funding and what you're not.
When a minister says, I'll take it on notice,
15
I don't know that you can eke out more information than that.
But surely you should come prepared.
Surely I've just told you 5 times that I'm taking it on notice. And that's the last year's budget. You could have asked me that in last year's estimates.
Tanya next.
I can ask whatever I want.
Okay. Thank you, Attorney General. I just want to get back to asking questions about the equality legislation, equality bill, and just trying to get that full title here. So you were saying that your office has, is your office working on anything at all in regards to that bit of legislation? Are they managing any brief notes or seeking legal counsel or advice?
So I'm not sure what you're getting at, Ms. Mahoney.
Well, the Quality Bill is currently before the Parliament. We know it's been extended to October. You've mentioned earlier that you are likely to have courage on behalf of the Labor Party, of the government. There's a note coming up to you. Just, can I ask you, is there, what work's already being undertaken in your office and within the department in preparation for that legislation?
I told you earlier that the government hasn't yet arrived at a position on.
Well, that's clear. That's why
that.
it keeps extending
That's
the
right.
date. That's right.
So what we'll be doing at the moment is receiving and considering submissions that people are making on an informal basis to our office.
Oh, okay, so there are now stakeholders separately notified.
People write letters to me and ministers all the time in relation to all sorts of matters, and the Equality Bill is one of them.
And you're meeting with stakeholders as well, I can imagine. Is that right?
My office is yes, and the department is
Okay.
yes.
Are you looking closer at, are you obviously examining what other states have done as well? Is that part of the process?
That'll form part of our considerations.
Okay. Because I note, as I mentioned earlier, that Queensland's bill of the Respect at Work and Other Matters Amendment Bill of 2024 has chosen not to consider any of the exemptions, looking at any of the exceptions and exemptions in relation to religious institutions, for example. That's not being considered by Queensland. My concern being, again, I reminded you earlier that 52 amendments to the ADA Act are being proposed by the Equality Bill, and you currently have a review which you don't into the ADA Act that you don't have an end date for, or any advice from the Law Reform Commission as to when that consultation paper will be made publicly available. Why would the government even consider the Equality Bill prior to a consultation paper coming out on the ADA Act review?
Because it's a bill that's before Parliament, and we'll work out when we arrive at a position.
But somebody must be going through the copious amounts of, that we're talking about.
I don't know.
80 amendments to 20 pieces of legislation.
It has been examined, but the government hasn't arrived at a final position.
But is a lot of time from your office, are your staff, specifically in the ministerial office, spending time on the Equality Bill?
They have been, yes.
Okay. Can I have they looked closely, for example?
Can I also just remind you that it's not a government bill.
No, I know. You could
it's
just
not
knock it
our
on its
bill.
head. It's a private member's bill. I appreciate that. I think that there's an easy solution. I mean, you've got an ADA review, and most of the amendments being proposed by the Equality Bill are actually to the ADA Act.
Some of them are.
52 amendments.
Across a range of portfolios.
Attorney General, I just want to ask specifically, have you met with any groups in relation to concerns around women's rights, for example?
Yes.
I think last time I asked you a question about who you met with, and you hadn't met with any women's groups at that stage.
No, that's not true. I've met with women's
But
groups.
you have since?
I have been meeting with women's groups and domestic and family violence groups since the day I was sworn in as Attorney General.
Mm. And they haven't, have people raised to you the concerns about self-ID checks, for example?
Yes.
And the impact on women's rights and children's rights?
Yes.
You have no view on that, Minister? You're not making a public view on any of this?
My view is the government's view.
what's the government's view? That's what we're trying to find
I
out.
know
This is
that,
the
but just-
third budget estimates that we're asking essentially the same questions. We can't get any answers.
These are hugely complex issues with serious ramifications. That's why we're taking our time to make sure we do all the assessments in an informed and basis, and not in a rushed way.
What about the issue of surrogacy? Has your office had reviewed, for example, what the Council of the European Union and the European Parliament have introduced in relation to the exploitation of surrogacy? Because one of the areas you're looking at, or this bill is looking at, is legalising international commercial surrogacy in New South Wales.
So, as I said, we are carefully considering all aspects of the Equality Bill, but on the Surrogacy Act, it's very complex, particularly in the context of children who are living in New South Wales with families who got here via commercial surrogacy agreements at some point. I've met with advocates who've made submissions to me about the processes that relate to surrogacy, and my office has met with the member for Sydney and Equality in Australia to discuss this matter. We made a commitment prior to the election to review the Surrogacy Act 2010 and the Status of Children Act 1986. That review's underway. Submissions closed on the 2nd of August this year. We'll consider those submissions along with information from all submissions made directly to us and from stakeholders on this complex issue.
And you've also seeking legal guidance into the consequences, the humanitarian legal consequences of commercial surrogacy as well? Is that part and parcel, I imagine?
There will be an all-encompassing review that the
So you'll be looking at what the European Union, for example, has had to say in relation to the exploitation of surrogacy?
Well, the initial the review will be done by my department, by DCJ. They'll look at things that they consider to be relevant, but now that you've reminded them to look at that, I'm sure they will.
Okay. What do you know of with self-ID checks, for example, in other states? What's already now legal in other states that you're aware of?
I'm not in a position to give you a discourse here about what may or may not be on the statute books in other states.
But you've said earlier that you would be looking into that. You want to be across that, don't you, to see what other states are doing it, to make a decision what New South Wales may do? And
in relation to self-identification on birth certificates and sex markers on birth certificates, if that's what you're referring to, New South Wales is the only jurisdiction that requires a surgical procedure for a person to apply for a change of sex in the registry. So we are considering that concurrently with and as part of our response to the Equality Bill.
Parental rights, and I've asked you this last time in relation to parental consent, and we talked about the Gilly competence at the last budget estimates. Do you believe, Attorney General, that parents have a right to permit and oversee any medical treatment their children receive?
It's not a matter of what I believe. It's a matter of what the experts say. And I don't have anything to add.
Who are the experts?
No, I'm not. There's a health,
but who are the experts that you're relying on?
Well, there's health issues. There's psychological issues that are in consideration here.
Have you met with any experts in relation to this issue? It's a big part of this bill.
I don't have anything to add.
Apparently, people in your office are actually working on it.
Can you let me answer the question?
Sure.
I don't have anything to add to that other than what I said to you in the last estimate.
Well, that wasn't very much, Minister, Attorney General. So I'm just trying to understand, given that you're getting closer to a government decision, what work has been undertaken in relation to parental rights and children receiving medical treatment?
Well, I think that's properly a matter for the Minister for Health in the first instance.
Is it? So the Equality Bill would make it legal for people under the age of 18 to undergo gender-affirming medical treatment without their parents' consent.
Yeah. And a lot of those considerations will be guided by the advice from medical and psychological experts.
And where do you find these medical, psychological...
when Ryan's sitting in this chair next week, you can ask
it's the
him.
health department, okay.
Yeah.
But you wouldn't seek any separate legal advice in relation to this?
The legal advice will be what implements the advice given by health experts.
Okay. Europe and the UK have emphatically walked away from the affirmative model of gender affirming care when it comes to minors. Why is New South Wales going against the international medical consensus by considering introducing these laws?
That's a question that is not directed properly to me, but the Minister for Health.
You're the Chief Law Officer, with respect.
I'll just answer that question.
So I think it is a matter for you, and you've just indicated to me that you've got staff within your office that are working as we speak on this equality legislation. They're clearly going to be preparing notes
And earlier in the day,
views,
I
and
said-
you will have courage on behalf of the Labor Party, on behalf of the government.
And that doesn't mean that all of the issues in that bill fall into my portfolio. There are some that don't, and on those issues, they are health and medical issues, as I've just explained to you.
Thank you, Attorney General.
Okay.
Good morning, Attorney
Good
General.
morning, Ms. Conn.
In 2014, I understand that the Criminal Records Act was amended to allow historical homosexual offences to be extinguished, and the formal apology by the Parliament earlier this year to those impacted by the criminalisation of homosexuality in this state, it was welcome and it was important, and it drew public attention to the opportunity for expungement. Is any compensation available for applicants who go through that process?
I'm not sure. I have to take that on notice unless someone can...
It's not a process that involves compensation, no.
Okay. And has any additional funding been allocated to meet the increased demand for expungement? For example, community legal centres?
I don't know. I'd have to take that on notice.
No.
I don't think so.
I'm not sure that we've seen any increased demand in recent months.
I'm certainly advised by at least one community legal centre that there has been. I'm also interested to know, and
That's
appreciate
excellent.
it maybe on notice, what communication is made with people with relevant offences about their eligibility for extinguishment?
We'd take that on notice if you like.
Look, many of these offences stretch back a number of years, and when people come forward to have their convictions considered, it's often a question of going back through court records that are sometimes actually quite difficult to find and sometimes are not in existence anymore. So it just isn't possible to go back through the court record and find all of these problematic convictions and be proactive about looking at their expungement. We do rely on people coming forward with their convictions, and when they do come forward, we look at them very carefully and we consider the issues very seriously.
Attorney General, when you spoke to the apology, you rightfully acknowledged the impact that these offences have had on some people's lives, their work, their relationships, their ability to travel. For people that have gone through all of that, to now have to proactively go through a process that's been described to me as fairly onerous, to have those records extinguished, would you consider providing additional support for people to go through that process without it being re-traumatising?
I'm happy for you to come and meet with me and suggest some assistance in that regard, sure.
All right, I will take you up on that offer. And appreciate these questions may need to be taken on notice, but I'm interested if the department has collected data on how many people that had been charged with historical homosexual offences are now eligible.
I'm not sure I understand the data you're looking for there. Perhaps very happy to take on notice the question. It might be helpful though to put those questions on supplementary, just so we're absolutely clear on the question that's being asked.
Sure, I'm happy to do that. It's referring to
happy
offences
provide
like
you with-
buggery and attempted buggery, which clearly have no relevance today.
Today,
Yes.
absolutely. Most of the offences are in the nature of offensive conduct offences, and prior to...
Sorry. Mr Chair, while Ms Conn is talking to Mr McKnight, could I duck out for 30 seconds, please? Is that okay?
Yeah, that does happen.
Yep.
I do have more questions for you in a minute, please.
You can have a break.
Apologies.
The
Many of these-
Premier did it the other day. Like, he set a standard.
Middle-aged
Sure.
men.
So, look, I'm happy to provide a written supplementary with those offences, and I'm also interested to know how many people have actually applied for extinguishment and how many of those have been successful.
Absolutely. I don't have those statistics in front of me today, but very happy to take that on notice. As I was saying, many of these offences are in the nature of offensive conduct offences, and they were committed in a range of situations. Sometimes they relate to quite obscure offences that were in what I would describe as random acts on the statute book that have now been cleaned up and have gone away. So it's often the case that actually it's not just the conduct that is coming to light. Sometimes the offences people were charged with are obscure and it's sitting in, the mid-21st century. We just don't know what those offences were. It's a complex issue. Yeah.
My further questions are for the Attorney General, Mr. Chair. Is it possible for us to stop the clock until he's back, please?
Can we stop the clock for just 1 second?
Yeah, we'll use government time.
We can.
Okay.
We'll give you an extra couple of minutes.
Thank you.
Thank you.
Cameron's got a point of order.
He's back.
Apologies, and thank you for the indulgence.
Thanks, Attorney General, and thanks, Chair, for allowing my further questions. I also have some questions about the Anti-Discrimination Act. During the apology, which we've already talked about, you said, and I'm quoting Hansard here, "No one should be discriminated against because of their sexual orientation. It should not happen today, and it should not have happened 40, 50 or 100 years ago." I agree with you, but as I'm sure you know, the Anti-Discrimination Act at the moment doesn't provide protection based on sexual orientation broadly. It only provides protection based on homosexuality and transgender status. So someone who is bisexual like me receives no protection at all. Do you support that very simple change to the Anti-Discrimination Act to provide protection based on sexual orientation and gender identity broadly?
Yeah, so as I've spoken earlier about this, one of the reasons that I refer the Anti-Discrimination Act off to the Law Reform Commission is because it's not fit for purpose for exactly reasons like that you pointed out. So,
Minister, I really appreciate that, and the Greens supported the referral to the Law Reform Commission. But last year, you passed an amendment to the Anti-Discrimination Act which extended vilification protections on the basis of religion, despite that review being underway. Given that this particular change is very simple, why haven't you treated it with the same urgency?
Because the protection of religious attributes were a part of long-standing efforts by Labor in opposition. My predecessor, former member for Liverpool and Shadow Attorney General Paul Lynch, brought 2 private members' bills before the House that were defeated by the coalition government. It was something that has been a long-standing effort of ours. It was the one thing that I said we would bring in respect of amendments to the Anti-Discrimination Act. For example, Ms. Conn, you might know that racial attributes are protected from discrimination and vilification, transgender discrimination and vilification, marital or domestic status, no protection against vilification, on the grounds of disability, no protection against vilification, carers attributes, no protection from vilification, age discrimination, yes, vilification, no. So there is a lot of work to do, and I had to draw the line somewhere, and we drew it at religious protections because that was a long-standing effort of the Labor parties. But if I was going to go down the route of doing a whole raft of other amendments, it would make a bit of a mockery of asking the Law Reform Commission to do that work. So my hope is...
You said that it was a long-standing commitment of the Labor Party. It's my recollection that the Honourable Penny Sharp, now Leader of the Government in the Upper House, tabled petitions to this effect while Labor was in opposition. Members of the Labor Party marched in the Mardi Gras alongside the Premier wearing T-shirts that said Labor, a future free from discrimination.
Yep.
And this is no longer an urgent commitment for this government?
It'll be a part of the review. I don't know that I can answer it any other way. They were the decisions that we made.
I'll go to my colleagues.
Thank you. Attorney, I know we've spoken about this in previous estimates, but I've had a few former members of actually quite a lot of former members of cults. Cults.
Yeah.
In contact with my office, and I'm really concerned that these people just have no way of accessing their assets that are held in trust by religious assemblies when they make the difficult and challenging decision to leave these coercive organisations. I've seen evidence of people left fairly destitute and open to abuse of these organisations. Are you aware of any particular protections for former members of religious assemblies who rightly want to control their homes and businesses and belongings when they leave these institutions?
That's a pretty simple question to what seems to me like a complicated answer depending on the personal circumstances of each individual and how their assets are dealt with. I don't know that I can answer that question the way you want me to.
But what if it seems that I know we've had a kind of brief discussion about it, or you may not recall, but
I don't recall that in either of my two estimates talking about cult members.
I raised it with you at the last estimates or the one before, and I'm just really curious about, there are laws that seem to enable this behaviour for some religious institutions.
So members of cults have signed over their assets to somebody else.
Whilst they're part of that religious association, and then they leave and they have no way of accessing their assets. And it seems like there's laws that protect this behaviour of these cults, for want of a better term, and individuals are roaming around New South Wales now, literally incapable of accessing mechanisms to be able to get control over their lives and assets again.
I'm happy for you to come and meet with me and with the department. We'll talk about what might be done there. But at the moment, if you've got, for example, a person who's of sound mind and body who makes a gift or makes a legal disposition of real or other property to someone, and then wants to revoke it later on, once the transaction's complete, I don't know that, absent any form of coercion or dishonesty or some behaviour on behalf of the recipient that might have invalidated that disposition, that there'd be much that anyone could do.
That's the reality. There are laws at the moment, whether it's, stewardship law foundations, or these are acts of the New South Wales Parliament that provide these institutions this kind of ongoing protection of these assets. And so, I think I'm very grateful for the offer, and I think perhaps that might be the next step. If there were laws that needed to change in order to provide...
So I'll take on notice what provisions currently exist that might assist people in that regard, and extend the opportunity for you to come and meet with me to educate us up on this a bit more.
Thank you. That's very good of you. Thank you. Back to you guys.
Yep. Thank you very much. Attorney General, in March you increased the threshold for bail for young people who have repeatedly engaged in break and enter and motor vehicle theft. This was limited to 12 months. Has there been a reduction in break and enter and motor vehicle theft?
I'd have to get some advice on that. I'd take that on notice.
Are you currently undertaking a review?
Of those, I think they're time limited to 12 months, those provisions.
Yeah. So will you be undertaking a review?
100%, yes.
So at the moment we're halfway through the implementation of those changes, and you have no data available at the moment?
We can get it. I don't know if we'll be able to ascertain anything meaningful from it, but we can get it. I just said to you a minute ago that I'd take it on notice. We'll find those statistics about how often those charges have been used, unless you want to hang on for a minute and I'll see if there are someone who's got a note about them. Okay, so do you want to know about the performance crime offence or the temporary bail test in relation to break and enter, or both?
Both, please.
Okay, so in relation to the performance crime, New South Wales Police initiated 19 legal actions for offences under Section 154 capital K of the Crimes Act between April and June of this year. So 19 legal actions. Of the 19 legal actions, 4 of them were cautioned under the Young Offenders Act. And 15 court attendance notices were issued. So 19 legal actions, 4 cautions, 15 court attendance notices. Of the 15 court attendance notices, 2 of them were issued to adults and 13 were to young people. Between April 24 and June 24, 2 Section 154K charges were finalised in the Children's Court. Both of them were proven. One defendant received a suspended sentence with supervision and the other one received a Children's Community Service Order. So that's in relation to the post and boast offences, if you want to call it that.
Sorry to interrupt, but my question was actually asking whether there has been a reduction. So I'm interested.
Oh, sorry, I thought you were asking
if you're able
about
to compare.
I want the stats.
You want-
You can come back to you.
Okay. So has there been a reduction in...
In break and enter and also motor vehicle
Oh,
theft
okay.
since.
I'll have to take that on notice. We rely on Box R for those figures, and if not, we'd have to go digging for them somewhere else.
And so
Unless you want to...
when I asked about a review being done, you are undertaking a review of once those changes came in, whether they've been successful or not.
Yes.
Yep. And when will that commence?
Well, it's time limited to 12 months. So at the 12-month mark, we'll ascertain whether they had what effect that regime had.
Okay. In response to a question in the Legislative Assembly on the 13th of March, you said that the laws would not increase the threshold for 17-year-olds accused of sexual assault while on bail for another sexual assault charge, and that, and I quote, the legislation is not perfect. What are you doing to address the legislation?
Sorry, I don't understand you. If there's not enough context here, I can't remember what the question was. I don't remember what my answer was.
I can hand you a copy of Hansard. I'm referring
Sure.
to the question that was asked in relation
Yep,
to
sure.
the bail laws, where you indicated they weren't perfect. I know, that's what I was going for.
Thank you. That's the question. Yep. So that's the question. I don't understand the context of the question.
And my question was, in that response, you said the legislation is not perfect. So I'm interested to know what you're doing to improve that legislation.
Oh, I can't remember what was in my mind at the time, but I was probably suggesting that it's not a panacea and won't solve all those issues overnight. That's what I meant by it's not perfect.
And are you taking any actions to address what you might think is not perfect?
Look, I've said in relation not only to those laws, but in all of the many acts that are under my purview, that I consider that all of those acts, all those legislative provisions are apt to be reviewed at any time. Nothing is written in stone, and if circumstances change, what a good government should do is to move to improve those provisions. So we'll be talking to all of the relevant stakeholders in relation to those provisions, the police, Aboriginal Legal Services, Legal Aid, and DPP, all of the relevant stakeholders, and we'll sit down after them and see what effect, if any, they've had and what we need to do from there.
That question was specifically in relation to sexual assaults.
Yeah.
So that's something you'll look at later on.
The question was how the new provisions will relate to a 17-year-old who's out on sexual assault. So, yeah, yes, same thing.
Attorney General, in Moree, sexual assaults have increased by 112% over the last...
Since when?
Over the last 2 years.
Yep.
And that's according to the latest box-up figures. In your opinion, is sexual assault a lesser crime than motor vehicle theft?
That's not a fair question. To lesser in what? In what?
Well, you've just
sense?
said that the bail laws are not perfect, and you're saying these are things that you'll look at down the track. You're tackling motor vehicle crime and break and enter, but when it comes to sexual assault, that's something you'll look at in the future. Is that correct?
No. If you have a look at the amendments that we made, that we spoke about earlier in relation to domestic violence, they contain considerations in relation to sexual assault. We'll be bringing in a new raft of measures in relation to breaches of ADVOs and things like that. So I'm not sure what your question is getting at.
This is about youth violence and sexual assault.
Yeah.
Not domestic and family violence.
Yeah.
Okay. I might refer to a press release that you put out on March the 12th announcing a targeted response to youth crime in Moree.
Yep.
And a 6-month action plan that would optimise service delivery in Moree. Now, has this plan been completed?
That's been led by the Cabinet Office, I think, isn't it?
The Premier's Department.
So there was a legislative response, and a non-legislative response for Moree, and the non-legislative response is being led by the Premier's Department, Cabinet Office.
So the Premier is responsible for the action plan?
Sorry?
The Premier, are you saying the Premier is responsible
No,
for the...
department's leading those...
And who's responsible for that department? Is it the Premier?
It's an across-government effort. It's an across-government effort coordinated by the Secretary of the Premier's Department, working with police, DCJ, health, education and a number of agencies.
And I'll go back to my previous questions. Ultimately, a member of the Cabinet needs to be responsible. Are you saying the Premier is responsible for implementing that action plan? And all non-legislative...
I'm saying that the organisation for the place-based responses in Moree have been coordinated through the Premier's Department.
I understand that, but what I'm asking for is who around the Cabinet table is responsible for getting an update on the action plan? Who is actually checking the plan is being implemented? It's not a person in a department or an office. It's ultimately a person around that table that is responsible. And are you saying it is the Premier that is ultimately responsible, or are you?
It's a team effort.
But who is who's getting the briefing? Who receives the minute? Who receives the information about and asks the questions about this action plan? Is it you or the Premier?
It depends on what aspect of the place-based response is being dealt with. So youth action meetings and things like that are dealt with by the Minister for the Police, but the Premier is taking a leading role in that, so it would be the Premier who's on top of that.
So yes. The Premier is responsible for the action plan?
I don't use the word responsible. We're all responsible for it. It's a decision of Cabinet, which is multifaceted, so we are all responsible. The Government, the Cabinet, we are all responsible for it. And each aspect of the place-based response being organised, coordinated through the Premier's office with assistance from the relevant department.
Attorney General, what is the status of the new bail accommodation in Moree?
That's one of the place-based responses I've just been talking about.
So who would be responsible for that?
I'd just rewind everything I've just said about place-based responses, insert bail accommodation.
So you're saying that ultimately there's no minister responsible, you're leaving it to someone in an office to drive your announcements?
Can I, in relation to bail, and I think
this is the bail
accommodation. Yeah,
accommodation.
In relation to bail accommodation, absolutely. The new bail accommodation support service for young people in Moree is very tight coordination with a number of groups, particularly local government and the Mayor, but it's been co-designed in partnership with local community stakeholders. So there is active co-design, and that issue is being worked through with community. And from memory, I think it is ready to the formal process for commissioning of that, or second tender, goes out at the end of September. If that is not accurate, I'll correct it on notice.
And again, I'll ask the question as to who is responsible for ensuring the construction that is delivered. Is it the Premier? Is there a minister ultimately responsible?
There is a governance group which provides accountability for the work taking place, and as I've said, it's coordinated by the Premier's Department, with secretaries working closely with the Secretary of the Premier's Department across DCJ, Education, Health and Police.
I might... Do you have any questions you want to...
I can jump in if you like, but I'm happy to. What do you want to do? I might just jump in and ask a couple of questions about Section 93Z, Attorney. Have you had consultations with the Director of Public Prosecutions in relation to the exercise of the Director's discretion with respect to the bringing of prosecutions in relation to Section 93Z?
I'd have to go back and check on notes from my regular monthly meetings with the Director.
Okay, so you have no memory of that coming up specifically?
I don't want to... we might have had general conversations about it, but you've asked about something very specific about her discretion,
No, it's just in terms of the structure of the legislation before it was amended that matters couldn't proceed without the Director.
In those specific terms, yes, I had a discussion with the Director before we made those amendments, and she expressed no difficulty with us proceeding in that regard.
Yeah. I wonder whether part of your consideration was driven by the two cases which police had successfully prosecuted, and I understand achieved convictions in relation to Section 93Z before they realised that under the legislation as was then drafted that those prosecutions had been improperly brought, that because they hadn't gone through the DPP, and then when those matters in respect of which there had been successful prosecutions were brought to the DPP declined to prosecute. Do you have any concerns in relation to that?
In relation to what aspect of?
Well, that two matters which have been the subject of a successful conviction, when they went to the DPP to essentially ask, the police asking the DPP to re-prosecute because they recognised they didn't have the power as the section was currently drafted, the DPP declined to exercise discretion to prosecute. Did you have any concerns about that?
I've got full confidence in the DPP and the decisions she might have made in relation to those matters. And I don't really want to talk about individual matters anyway.
Okay. Did your discussions about these matters inform your decision to refer the operation of 93Z to the Law Reform Commission? Oh, look, sorry, I shouldn't have asked you that question. I withdraw that question, Chair. It was made while you were on leave, that decision, wasn't it? That was the Premier's decision, not yours. Is that correct?
Yes, we've been through over that.
Yes, no. It's my notes. Is there a timeline for when that review will be finished?
So I'll refer you to my earlier answers in relation to the Law Reform Commission review of the Anti-Discrimination Act, and the answer is no.
Okay.
But I can
have
give
you
you
read the Law Reform Commission's option paper on serious racial and religious vilification?
Sorry, what was the question?
Have you read the Law Reform Commission's options paper on serious racial and religious vilification?
Yes, I have.
And you're aware of the proposed changes that are canvassed?
There's no proposed changes. They're canvassing, well, the elements of those issues. There's no proposed changes.
In budget estimates earlier this year, Deputy Commissioner Malcolm Lanyon told us that the reason no arrests were made at the Opera House protests almost a year ago was because there was no specific individual to whom the possible offences could be attributed. Would any of the changes canvassed in the options paper have any impact on that situation?
Well, my understanding of those comments is that the police didn't have any evidence to proceed. Police, regardless of, unless you want to legislate for police proceeding to prosecute people with a lack of evidence, no.
So, so you're saying that a problem... So did you perceive that there was a problem with 93Z that no successful prosecutions could ever be brought in relation to those Opera House protests?
So say that again?
Did you perceive that there was a problem with 93Z because no successful prosecutions could be brought in respect of the Opera House protests?
No. No, you're linking... No, that's not correct.
So you didn't see that as a concern with 93Z?
Concerning what regard?
Concerned that there were groups of people disrupting a prayer vigil at the Opera House, yelling out all sorts of things, and yet 93Z was apparently ineffective to be able to prosecute anybody. You were not concerned by the lack of prosecutions at that Opera House protest?
I can't comment on what may or may not have actually, what behaviour may or may not have occurred there in relation to fitting within the elements of 93Z, or why the police were not able to proceed with the prosecution. You're asking me a question about things about which I can't have the requisite knowledge.
I'm asking you your view about 93Z and your concerns about its operation when there was clearly considerable community concern that it did not operate to protect a prayer vigil at the Opera House.
That's you characterising it in that way. There's nothing specific that you've asked me there that I can meaningfully respond to, Ms. Carter.
One of the possible changes canvassed, as you've indicated, is increasing the maximum penalties. Do you think that this would send a strong message about the gravity of inciting?
I'm not going to preempt what the Law Reform Commission's report might say. I'm not getting ahead of myself there. We'll wait and see what happens when they send their report back.
So you don't have a view about the success or otherwise of increasing penalties to send strong messages about undesirable behaviour?
Whether I've got a view or not is irrelevant. It's what the Law Reform Commission sends back to me to have regard to, and they haven't sent it back.
But you had a view about penalties in relation to knife crime, did you not?
That's because the government made a decision. Now you're asking me to... I'm not looking into a crystal ball.
So I'm curious,
Ms.
Mr.
Carter,
Attorney General.
don't bother going there. You can if you want to. You're going to be wasting whatever time you've got there.
I'm curious, Mr. Attorney General. You keep referring to the government as if you are not a part of that government.
Government's on one aspect of it. The Cabinet makes a final decision on issues.
But you seem to be presenting yourself as a very junior player in the government. Is that correct?
No, I'm not.
And
that's your
could
characterisation
you perhaps
of it.
outline for us exactly which of the initiatives that you introduced to Parliament, which of those you actually have ministerial responsibility for their implementation?
Which acts?
Yes.
Go back over the Hansard and have a look at all
Jack's
the
Law.
acts.
Are you responsible for the implementation
it
of that?
depends on which act that's been amended, and if it's my act under the Allocation of Acts Act, it's mine.
Jack's Law from memory amended
Summary
Leper.
Offences
You're
Act and
responsible
Leper,
for
yes.
Leper, aren't you?
Yes.
So you're responsible for the implementation of Jack's Law then?
Yes.
And you're responsible...
Jointly with police, because the subject matter revolves around police procedures and equipment and standard operating procedures and things like that.
And you're responsible for the implementation of the changes to the DV laws, the electronic monitoring, the magistrates, the show cause for bail?
Yes, in terms of bringing the legislation before the Parliament, but in terms of the implementation, as we've been over several times, there are other aspects of the implementation. For example, the electronic monitoring that's been done by corrections.
And who's responsible for that?
Well, we've been over this. Go and look at...
We're coming back to it because there has been no answer, Attorney General. Which minister has responsibility for the implementation of these laws?
Which ones?
The electronic monitoring.
Oh, we've done this to death.
Then the answer should be on the tip of your tongue, Minister.
Yeah. My legislation, Minister for Corrections and Corrections for the implementation of electronic monitoring.
And magistrates.
Not the implementation, no.
Who's responsible for the implementation of that?
Of what?
Of the magistrates, not registrars, hearing bail matters.
Me.
So you are the minister responsible for it?
Yes.
Thank you. I think my time's up.
Okay, thank you, Chair. Attorney General, I'm just going to go back to the Equality Legislation Amendment that you have indicated to budget estimates today that you have carriage over, together with bits and pieces to other ministers. So what is the full title right now of that legislation? What is it? It's Equality Legislation Amendment.
I don't know. I have to go back.
Do you know what the name of the full bill is? That you've got full carriage over? And your
no.
staff in your office.
Well, we just refer to it as the Equality, Alex Greenwich's Equality Bill. What the long title?
It's got a
or the short
name.
title
What's
is?
the full title?
I don't know.
How can you not know the title, Minister?
Well, why don't you tell me? You've got it in front of you. So
you've got carriage of it.
At the moment, we just refer to it as the Equality Bill. It's not a government bill.
Okay. But it's a pretty big piece of legislation that has twice now been delayed, and it's with, you've told me you've got full carriage of it. I've got to say, Attorney General, I've got stakeholders telling me that rather than you having carriage of it, it's been put to them that it's in fact with the Premier and the Cabinet's office. Is that right, with the PNC?
Government's made no decision on it.
Well, who has carriage? Would you say the Premier has more involved in this, or yourself? I mean, you're telling me you've got carriage. You can't give me the full name of the piece of the bill.
I'm telling you that the government has made no decision, and that's it.
Stakeholders are telling me they've been told to bypass your office and to actually deal with the Premier, and the Premier and Cabinet's office are in fact dealing with the finer detail of their legislation. Would you say that's correct? That they are in fact
the government's
dealing with
made
finer
no
detail?
decision on that legislation.
Okay. What do you define as government? The Premier and Cabinet's office? Are they government?
Cabinet's the government.
Okay. They've made no decision. Who's going through the finer detail in relation to this legislation, which I think the full title is Equality Legislation Amendment LGBTIQA+.
The government has made no decision on it.
Mr. What does the plus stand for?
The plus relates to, let's go through it.
Yeah.
L.
You know now, it's in
gay,
front of you,
bisexual,
right?
transgender.
Yep.
Plus.
I, intersex, yeah, it's been given to you some notes.
Symbols generally used to represent those who do not identify with one of the letters in the acronym, for example.
I'm glad you got a note there, Minister. I'm glad you got a note, but
right.
I would have thought you might have been on top of that acronym.
I know, wasn't that just one of the highlights of parliamentary democracy in New South Wales?
Well, it is. I've got to say, I wouldn't be laughing about it because I wasn't one that I expected to ask. I just assumed you knew the title of a piece of legislation that you have just told us an hour ago that you've got carriage over, that your office and that staff in your office are dealing with the specific details of this legislation. It's not a gotcha moment. I'm just surprised that you didn't know that. That's all. And it might make sense why stakeholders are telling me that, in fact, the Premier's office has taken over the full carriage of the Equality Bill. Would you suggest that's right? Would you agree with that? The Premier's office is
doesn't matter how many times you ask me where this bill's up to, I'm going to give you the same answer.
And that is that you don't know, or it's up to government?
The government has made no decision on final aspects
there's a
of that
deadline
bill.
of October, is that right? There's a parliamentary deadline of October, is that correct?
What deadline are you referring to?
The deadline in Parliament, how it's been extended. I mean, there are time limits to private members' bills in the House.
It's up to the House to extend it again if the House wants to.
Well, it extended it on the back of the government leader of the House suggesting that it be extended because a decision hadn't been made by government. Isn't that right? You had no role in why it was extended last time?
It was extended because the government's working with the member for Sydney and we haven't arrived at a final position yet.
I think the member for Sydney indicated he was unhappy with the extension publicly. Is that right? All right.
I don't know what you're referring to.
I have no further questions. Thank you.
Thank you. Ms. Boyd.
Thank you, Chair. And good afternoon.
G'day, Ms. Boyd, how are you?
Attorney General, very well, thank you. Can I just start with the Coercive Control Task Force? I asked some questions on notice a couple of months back, asking about the remuneration of individuals on that task force. And I understand that the independent member is not remunerated for their time. Are you aware of that?
No, but one of the fine officers here can assist me with that.
If you're referring to the chair of the Lived Expertise Reference Group.
Yeah. There's also independent member on the...
Yeah, so my understanding is that the community members are remunerated. If that is not the case, I'll correct that in my evidence this afternoon, but my understanding is that they are. Those.
If you could look, I'm referring in particular to Annabelle Daniel, who, as you know, is
I can
very
deal
well
with Ms. Daniel.
respected.
So it is proposed, and I'm talking about an individual here.
Yeah.
There is a process in place to address remuneration to Ms Daniel.
Okay,
it
so
would
that's
require-
already been picked up as being an issue.
Ms Boyd, it would require, as I understand it, a ruling of the Public Service Commissioner. The machinery to deal with it has been activated, and that is the plan.
Okay, so you're aware of it, you're doing something
Well aware of it,
about
and it's well progressed.
Okay, good, thank you. We spoke last estimates about safe waiting rooms in courts for victim survivors of domestic and family violence in particular. And I gave you examples of where in some cases, in some locations, the safe waiting place is sort of under a tree nearby as opposed to actually in the court. Where do we still have gaps in that system? How many of our courts now have a safe waiting room?
I'm not sure if Mr. Deeth can help me with that, otherwise I'll just take that on notice.
Just one moment, I'll just take the information on that. Thank you. In New South Wales, 78% of courthouses are heritage listed and 70% are over 100 years old, as you might be aware.
Sounds like an excuse coming.
A small number of court locations are too small to include a dedicated safe room, and site constraints such as lot size, room layout and heritage and security considerations can present difficulties. In some instances, the safe waiting area is off-site at the police station. Safe waiting arrangements are determined by considering factors including the size, layout of the waiting area, access to sheriffs, location of security cameras that are monitored by the sheriffs, and the use of monitoring and duress alarms.
Okay, so we're not getting then safe waiting rooms in every court. Is that what I'm hearing? Because even under the last government, they committed to make that happen.
Yeah, I think we'll have to take that on notice.
Thank you, if you could. Similarly, how many courts and police stations have well-functioning and reliable AVL technology in order to allow victim survivors to give evidence remotely?
We are upgrading AVLs, and we spoke about this earlier in relation to weekend bail.
Is that the $6 million emergency?
It's a $4 million. That particular component of the $45 million is the $4 million.
Yeah, so I'm not sure if any of those AVLs will be able to assist in that regard as well, but we're happy to look at that.
Be good to know just how
I've got a very
far off
long
we
and
are.
detailed note here, which I won't read out, but you might.
Yeah, perhaps
But
we
also,
could.
site specifically on these two challenges.
Yeah.
If there are particular sites where you are aware that there is an acute need, because there is a challenge with quantum of funds,
Yeah.
as Mr. Date's response has indicated. But if there are particular locations where the problem is acute, we're very happy to engage.
Okay, I appreciate that it takes time and that there are obstacles sometimes, but I guess what we're looking for is to know that the department understands what it has left to do, and then we can have some sort of timeline as to when it will be completed.
Well, yeah. So, as Mr. Tidball said, if you have any submissions about that, or people, we're all ears. 'Cause
Okay.
we want to get on top of that as well.
When will the government honour the 2023 election commitment to appoint an independent advocate for all victims of crime?
Yes, so we are doing a statutory review now on the Victims' Rights and Support Act, and that's a key election promise to do that. I can't give you a specific time frame, but we do intend to honour that as soon as we can.
Okay. Is there a reason for the delay?
I'm looking at the whole Act and scheme in the context of the statutory review, and we're going to do all of that.
So when can we expect the outcome for that review? Because
I can't give you a time frame, but it's not being delayed for any purpose. We're having a detailed look at the scheme as a whole.
Yeah, okay. Because I understand that that's been delayed a little while as well. I think that was due in 2021. Am I thinking of the right?
Yeah, and so because we're in new government.
Yeah. Getting less new, unfortunately, by the month.
But that's true, but we wanted to start from scratch and have a look at that
Okay.
scheme as a whole to make sure that viable in the long term.
Are you able to give us any kind of timeline?
No, but all I can say is there's no attempt to delay it for any particular reason. There's just a lot of work to do.
Okay. The Domestic Violence Death Review team was a bit delayed in releasing its latest report. We were waiting for some time. Is that team being adequately funded?
I want to thank the team. I had a meeting a couple of weeks ago when they did release their latest report with the magistrate to the coroner, Teresa O'Sullivan, and the two women who constitute that team. They do amazing work, and they've just done a deep dive on domestic violence murders over the last 20 years, I think. And the work they do is amazing. I'll take that on notice, but I think that as part of Minister Harrison's $236 million augmentation, I think some of those funds, correct me if I'm wrong, was it $2 million?
$2 million.
$2 million to augment their funding.
Okay.
Yeah.
And was a lack of funding the reason why that was so delayed? I understand it was prepared.
I don't know when it was supposed to have been.
I don't think that was the reason, but I can come back in the afternoon and provide you a response.
Thank you. That would be useful. The community legal centres have been kind of, as I understand it, a bit left out of the other frontline services when we come to talk about domestic and family violence. And given that the community legal centres do significant amounts of DV work, is there a reason for that? And are we looking to sort of adequately?
So community legal centres, legal aid are funded under the National Legal Assistance Partnership Program. That funding runs out in June of 2025. So we are in the midst now of negotiations with the Commonwealth and all the states at SCAG to come up with a new NLAP agreement.
Okay, so they're not considered within that sort of frontline domestic violence funding piece because they are dealt with separately under a different funding.
They're administered by legal aid through the NLAP funding arrangements.
Okay.
Which is a combination of state and federal funding, but mostly federal funding.
Okay. Just one last question and then I'll hand back to my colleague.
And National Cabinet's on Friday, and I'm hoping that there might be some more money forthcoming
Fingers
from the
crossed.
Commonwealth. I don't know if there is or there isn't, but I'm hoping there will be for domestic violence.
The Your Reference Ain't Relevant campaign, since we last spoke, the Sentencing Council has got their submissions in and closed the date for submissions. I think that was the 9th of July, so it's, we're still quite sort of early after that. But do you have any sort of timeline of when we can expect
No, I
them
don't
to come
know
back?
when Judge McClellan will hand that report back to me, so I can't assist you there. I don't know.
Okay.
We don't put a time frame on those, either them or on the Law Reform Commission, and they don't publish an anticipated time frame either.
I understand that there is a piece of legislation coming soon that's dealing with some of those sort of child sexual assault. No? Did I dream that one? I may have dreamt that one.
Don't know.
Oh, okay. Thank you. Thank you.
Attorney, I'm just curious, how many times, if any, has the Children's Court exercised the power in Section 85 of the Children's Care and Protection legislation to request provision of a restoration service to a child or young person or their family in order to facilitate the safe restoration? I think this was a question I tried to put yesterday, Mr. Tibble, but I think it belongs in this estimates.
Maybe Mr. Tidball's got the answer now, but
I'm happy
it's
to.
pretty specific, so I think we'll better take that on notice.
Yeah, I mean, it's about the amount of times the courts exercise that power, really. So it's a question about the courts. I'm happy if you want to take that on notice, and thank you. Just out of interest, Attorney, who's going to be attending the National Cabinet meeting? Will the whole Cabinet Office be there on behalf of New South Wales?
No, I think only premiers get invited to that prestigious gig.
Right. I was just curious. Just seems like the Cabinet Office is where everything... we love collaborative decision-making, of course, but just wondering about these events.
That's good, because there's plenty of that going on.
Good. Attorney, it would not be a budget estimates if I did not ask you, when are you intending to raise the age of criminal responsibility in New South Wales?
There are currently no plans to raise the age.
Why?
Okay, why don't we just go back and read the transcript from the last two estimates? Nothing has changed.
Because, Attorney, I am asking you in the deep anticipation and hope on behalf of all of those incredibly hardworking advocates and experts of all relevant expertise who are just really imploring you for a different response. So is there nothing that you would add that is slightly different in anything in regard to all of the evidence on the table about the importance of raising the age of criminal responsibility?
No, there's nothing I can add to what I told you in the last estimates.
Okay. Could you explain to me why, when all of the evidence is suggesting that it would be the most reasonable and sensible thing to do through the lens of youth justice, community cohesion and actual genuine welfare outcomes for young people?
I have explained this to you on two previous estimates, and as I explained,
Remind me.
Passing a law to raise the age is the easy part. It's the alternative pathways that need to be built to treat these young offenders who are not going through the criminal justice system. At the moment, those pathways do not exist.
So what are you doing to fill those pathways, Attorney?
I've asked the department to come up with some plans for what alternative responses might look like, and I'm hoping that the responses in Moree will go some way to be used as a pilot program in that regard.
So how many young people have been signed up to an NRL star? How's that one going?
I don't know.
You're not
What
sure?
do you mean?
Who do I ask? How do I find out?
Signed up to an NRL star?
Yeah, you know, mentored with one. How many young people? And
I think that's a program that's been run by the police.
Police, yeah, probably.
By the Youth Command. And
I'll ask the
Paul
cops
Pizanos, who's
how that's going.
an excellent officer.
Okay. So what else are you seeing in Moree that, what else can you tell us about these alternative pathways rather than just locking kids up?
In what regard?
Well, about what the reason you're not raising the age, because that's the easy part.
Yeah,
you could
so
do that tomorrow.
So when the department does that work, I'll have more to say.
Okay, and when will that work be done?
I'm not sure.
Oh.
But
is there some plan?
I haven't put a time frame on that. I want the department to go and do all of the discussions with other stakeholders that they need to, and then come back with something that we can work on.
Well, which stakeholders? Because all the stakeholders that I'm aware of out there, and there are many of them. In fact, let's consider that. How many reports have you read that say that we should be raising the age and that the evidence is so clear? Which other stakeholders will you be talking to, if it's not the ones saying you should raise the age as a matter of priority?
It would be the ones that would provide, for example, alternative therapeutic pathways for children who are troubled, who wouldn't go down the justice system but might need to live in some accommodation service where they receive counselling and therapeutic treatment, those sorts of stakeholders.
And so are those stakeholders suggesting that you shouldn't raise the age tomorrow, like you said you could?
No, I'm saying that you asked me when, and I'm saying that the department's doing some work to come up with what alternative pathways might look like.
So are you able...
And I'm in discussion with other states as well, and no other states, as I understand it, have really come up with a definitive gold standard place-based treatment, if you like, for these pathways, and that's why there are different views amongst the states about whether they will act or not act. Or
there's very different views. Look
are.
at the Northern Territory. It's looking disastrous, Attorney. I hope you're not looking too close there. Are you able to provide the committee with a list of stakeholders that you're working with on this particular issue?
I'll take that on notice.
Thank you. Just in relation to Moree and the facility, that I think Mr. Tibble said something to the effect of contracts would go out at the end of September, or tenders, sorry, for what are you actually envisaging there? What's in your vision, Attorney General?
That is, I was speaking specifically in relation to the bail accommodation component.
Yes.
Which is, the intention is we are working to co-design that with the Aboriginal community.
But so can I just ask what the government's vision part that it will be bringing to the table about that? I'm actually a bit confused about what you have in your mind's eye about bail accommodation in Moree.
We just have to wait and see what they come up with.
Okay.
It'll be somewhere to take young children to who are on bail so that they can get proper therapeutic treatment rather than just being thrown into a juvenile justice detention centre or something like that.
But just in terms of the design, our approach is a partnership approach with the Moree Plains Shire Council and the Coalition of Aboriginal Peak Organisations to genuinely co-design it, which is why we have taken some time to get to this point. But that is what we are doing. Then there is a suite of other activities that are being developed in the community to ensure that there are...
But can I just ask on this?
Order.
Don't I have another 2
No,
minutes?
you don't.
Yeah,
No, you don't. You've had yours.
We're happy for her to start and then we get
Thank you. I just have one final
you're
point
finishing
on
at quarter
this.
two. Yeah.
I have one final point on this. Didn't the Parliament say that these bail laws would come to some kind of fruition in 12 months or be reviewed?
That's the bail legislative responses to bail to the crimes that were spoken about.
Yes.
But in addition to that, there are place-based responses in Moree where we're working with community, working with the council, working with the police to do things on the ground in Moree.
You are literally doing a facility that won't even come online before the laws that you enacted to deal with these, where these facilities were meant to be, the placation of all of the harm, and yet those laws will be coming to an end by the time the facility's broken. I think it's a mess. I think it's a genuine mess, and I think you have, in many ways, misled the New South Wales Parliament and misled the New South Wales people about what the government's intention on these youth bail laws, particularly in Moree, really is.
Okay, so I'll take that as a comment.
Thank you. Please do.
Susan.
In fact, I had a question on the same line. Will the facility at Moree be ready before the bail laws expire?
Yeah, that's what it is.
In terms of the timing,
Yes. Yeah, because we're 6 months into a 12-month bail law change, and we're still planning this facility in Moree.
But I think the drivers for the Moree facility have not been about changes to law. There have been to legislation.
That's how they were
there
solved.
Sorry, it's a very specific question. Will this facility be ready to accept young offenders before this law is sunsetted out of existence?
We'll wait and see what the work of the committee is, and we'll take that on notice in that regard.
So we're 6 months in.
So, Mr. Chairman,
do we realistically believe it's going to be built?
I've just answered that, Mr. Chairman. I'm just conscious of time, and I did undertake to answer some questions on notice.
It's still our position time.
You still get
government times.
Can I get some guidance from the Chair about that?
Nearly 3 minutes of questions of you, Minister.
Oh, in the past, you've asked me to read these in during...
We're now actually wasting
We can
opposition
do
time.
that
We're
if
wasting
the
time.
government has no questions for you. We can do it in their time.
A question about the young offender bail laws. You've undertaken that you will review them. Will you be extending them if you find in your review that they have been a successful deterrent to crime?
I'm not preempting anything about the extension or otherwise at the moment.
What's the purpose of a review if there's no action to flow from it?
I'm just telling you, I'm not preempting any decision in that regard. One of the purposes of the review will be to see what effect, if any, they had and whether they worked or what the ramifications of them were, what the numbers turned out to be, whether it reduced crime, all those things.
Attorney General, back to the place-based response to Moree, and I know that there is a nameless, faceless person in the Cabinet office that's ultimately responsible. But I wanted to know whether or not you would be responsible as Attorney General for the additional judicial resources for local and children's court jurisdictions, including associated legal aid, Office of DPP and police costs.
Yeah, they come within my... Sorry, the police cost, did you say?
That's the bracket from the press release. But it was additional judicial resources.
There is additional magistrate temporal.
Yeah, we've been... Yeah, that's right, yes.
And in the press release it said it will be for 6 months with additional funding for Aboriginal Legal Service. How much of that $13.4 million has been spent?
Unless Mr. Deeth can help me out here, we'll take that on notice.
Okay, so it's for only 6 months. Was that from when this was put out in March, or is it from next month, or?
The timing depends on when the Chief Magistrate, I think, wants to engage that.
So you have no time frame?
The additional temporary magistrate for Moree region for 6 months will be commencing on the 26th of August, so it's already commenced.
Already commenced.
Yeah.
Okay, thank you.
All right, it appears time has come. One more question.
One last question. Is there any move on foot to look to expand the Wallumer list into the Northern Rivers at this point in time?
I think the Wallumer list is undergoing an evaluation, so there'll be no plans to do anything with it until that evaluation is complete.
Is there a timeline on the? I should know, but I'm not.
Yeah,
aware.
I've forgotten that as well. I don't know. I think it's next. It's 25 sometime.
Okay.
Yeah. But
Thank you.
We'll take that on notice. So.
Thank you.
Government questions? There are no government questions? Attorney.
All right. Mr. Chairman, a question was asked, who provided submissions to the statutory review on protest laws?
Yes.
Answer, a campaign submission from 1,318 individuals, 45 submissions by individuals that were not part of a campaign. Do you want me to read slowly, Ms. Higgins? So you can, right, yep, okay. Including 3 by academics.
Yep.
There were 7 submissions from NGOs. 6 submissions from trade unions and other bodies representing workers' interests. 3 submissions from legal stakeholders. 1 submission from the New South Wales Police Force. Question 2. When will Jack's Law be proclaimed? An implementation task force is being led by the Premier's Department. The precise commencement will be determined by police readiness. Next question. How much money has been allocated in the budget for Jack's Law? The answer, there has not been a budget allocation for these laws at this point in time. As is the case with any new government initiative, budget will be allocated if and when required to operationalise the laws. Next question. Can you remind me on who was consulted during the consideration and making of the wanding powers? Do you recall speaking to the bar? Do you recall consulting with the Law Society? Did you consult with the LEC? Answer, the bill was drafted in consultation with the New South Wales Police Force and the Cabinet Office. An early draft of the bill was provided to Legal Aid New South Wales, the Office of the Director of Public Prosecutions and the Public Defender's Office. Next question, will the LEC be asked to review the Jack's Law training materials? Answer, no, but the reforms will be closely monitored. Under the Law Enforcement Powers and Responsibilities and Other Legislation Amendment Knife Crime Act 2024, there is a statutory review 2 years from commencement and the reforms sunset at 3 years. Next question. Who did you consult with on the youth bail? Did you consult with Bar, Law Society, ALS? Answer. The measures were discussed with the Coalition of Aboriginal Peak Organisation in broad detail, and the Premier's Department also visited the Moree community. No other external stakeholders were consulted. DCJ has convened a cross-agency monitoring group to consider the impact of the laws in consultation with Boxar. The group includes government agencies as well as representatives from the ALS, Legal Aid and the Children's Court. Next question, what were the outcomes of the consultation in review of the break and enter offences in regard to BA and the King? Answer, consideration of the outcomes of consultation remains ongoing as the consultation raised many complex issues. We are not yet at a point where we can say what the outcomes of that process were at this stage of the process. Question, list of the membership of Implementation Task Force, how often do they meet? Answer, the Cabinet Office are leading an implementation task force that includes a membership from DCJ, relevant policy areas and courts representatives, correction, police and legal aid. On average, the task force has been meeting fortnightly. Question, what is the budget for electronic monitoring? Answer, the costs of the electronic monitoring program have not yet been quantified. The implementation task force is working through this detail. As with any new government initiative, budget will be made available to support the government's commitment. Question, there's only 2 left. Will the new targeted laws lead to more young First Nations people being incarcerated? Answer, the Department of Communities and Justice has convened a cross-agency group to monitor and report back on the impact of the provision. Boxar has been engaged in this process. The work of this group also involves seeking data and feedback from other agencies on the operation of 22C, noting that the Boxar data is indicative only. Boxar's preliminary analysis has identified 66 first bail appearances from April 2024 to June 2024 inclusive, where the matter was within the scope of 22C of the Bail Act, noting that Boxar data is indicative only as our system does not record precisely all of the matters that fall within 22C and where 22C was a determinative factor. Of these 66 appearances, 56 individuals, 85% that is, involved defendants who were Aboriginal. 52 individuals, representing 79%, resulted in court bail refusal and the young person being remanded to custody. Of the 52 appearances resulting in court bail refusal, 46 individuals, that is 88%, involved defendants who were Aboriginal. 53 individuals, that is 80%, involved defendants from regional New South Wales. And finally, of the 52 appearances resulting in court bail refusal, 42, that is 81%, involved defendants from regional New South Wales.
Thank you,
Now,
Minister.
Mr Chair, might I just make a brief closing statement, if you would
Sorry,
indulge me?
statement?
Yes.
Please.
On the last occasion of estimates, and I'm not directing these comments to anyone in particular, but I was watching those proceedings where departmental officers and statutory office holders, including the Director of Public Prosecutions, were being questioned. And I considered, having been involved in this game for a very long time, that some of the tone and manner and demeanour of the questions was rude and disrespectful and unbecoming members of the Legislative Council, given that these people are servants of the government of the day, regardless of their political colour. They are experts in their field, and I would have expected that they might have been afforded a bit more protection from the rudeness and inappropriate questioning. And I would ask members of this committee respectfully to treat these officers with great respect this afternoon, and that you might be particularly vigilant, Mr Chairman, to ensure that that occurs.
I will, Attorney, noting that we now have standing orders where they can actually deal with any major transgressions or rudeness that we never had before.
Great. Music to my ears. Thank you to you and to the committee.
All right, that brings to an end the attendance of the Attorney today, and we will return at 2 o'clock after lunch. Thank you. Yeah, we might get started again now. Thank you. Yep. Okay, we'll recommence. It's now 2 o'clock, and we'll commence with questions from the opposition.
I think, yeah.
No, we switched.
We're going to start with you?
Yes,
Okay, we'll start with the
yes.
crossbench.
Thank you all. I'm just, actually, if I
Sound
could
good?
start with asking Dr. Cocaine about, I'm just curious and wondering if you could update the committee in relation to the work that you're undertaking now, and also in particular in relation to any of the work practices that are happening across New South Wales in relation to workplace visas in New South Wales, and if there's any work in that area being undertaken at the moment.
Thank you very much, Ms. Higginson. Yes, I think that was a question in 2 parts. I'll try to answer in 2 parts.
Yeah.
In general, we have a very busy program currently. We see a significant increase in requests for support and assistance from me in my office under Section 9(1)(b) of the Act. So that's direct support and assistance to survivors of modern slavery. And we have increasingly complex matters. What I would say is that our hotline that we now provide on 1-800-FREEDOM, so that's 1-800-37-33-36, is emerging as something of a fail-safe for survivors that are struggling to get support and assistance from the system. And that might be, for example, to come on to the second part of your question, because they are out of valid visa status, for example. So that prevents them accessing most of the federal government funded supports and assistance, and can create real difficulties for them, even, for example, to access basic health care. I will be tabling for the first time a report under Section 19(4) of the Modern Slavery Act. That's a report that allows me to present, a provision that allows me to present reports to the Parliament on my own motion. I'll be presenting such a report to the Minister, who then, under the Act, will furnish it to the presiding officers in the next probably 2 to 3 weeks, specifically looking at the vulnerability of temporary migrant workers in rural and regional New South Wales to modern slavery. That draws on the 2 years I've had in the role, over 12 regional visits, support and assistance to over 30 such workers. And I don't want to preempt the report, if you don't mind.
No.
But we'll certainly be presenting a quite detailed study of those challenges that temporary migrant workers in particular are facing across New South Wales in the coming weeks.
And can I ask, does your report style take on findings, recommendations? Is it that kind of report style?
Yes.
Yeah.
What I would say, though, is I don't have investigative power under the Act. So we necessarily have to temper how prescriptive we can be based on the evidence we have that has come our way rather than we have gathered, if I can make that distinction. I don't have investigative power, so we're relying primarily on information from consultations we've undertaken and from people who've presented for support and assistance.
Thank you. And can I also ask you, I think I might have raised this with you in the last estimates, and I should have checked, but looking at the current system of labour in New South Wales prisons, and whether that is something that has come across your radar, whether it's something that you feel empowered to look at. I have received a lot of complaints and concerns about the labour force within our prison system in New South Wales and the thousands of people in custody, and the fact that they work and yet receive very low remuneration for that work, and at times, and just wondering if you have any views on that, or if you think you have any capacity to look at that.
It has come up in our work through 2 different directions. First of all, we have had information shared with us, which I guess you would characterise as whistleblower information, about work that appeared to be involuntary, undertaken or forced to be undertaken in various carceral settings. so not only prisons but other carceral settings in New South Wales. We've undertaken some inquiries using my powers under Section 14 of the Act to seek information. We've also had questions from both public sector and private sector entities that have reporting obligations in relation to products in their supply chains. So there are both public sector and private sector entities in Australia, in New South Wales, that are purchasing goods made through prison labour in Australia. Prison labour, of course, is not per se illegal. There are some quite complex rules under international law, and I should note that the relevant committee of the ILO looked at this just a couple of years ago in Australia and had very little to say about the New South Wales arrangements. For our part, having received those inquiries, we have been undertaking some work to look at the voluntarity of work being performed in prison and carceral settings, including through CSI, which is a matter for the Secretary. We have not yet reached any firm conclusions, and the reason for that is simply resourcing. We have not had adequate resources to undertake that work at the speed we would have wished to. We have to, like everybody else, prioritise, unfortunately.
One of the concerns, and I don't know if you've heard it too, but one of the concerns I hear from inmates is that, you know, economic injustice is one of the greatest contributors to inmate abuse and violence and, lack of cohesion within prisons, and it's because of this lack of access to, what inmates consider a decent pay for the work that they are doing. So I'm just, it would be good to know that your office had capacity to look at that.
We certainly
matter.
intend to keep pursuing the matter as resources allow.
Thank you. Secretary, I'm just wondering if you have any information about, or whether it's within your remit in relation to sheriffs and their conditions and the concerns that we're seeing with sheriffs. And I know in my region there was a kind of standoff work, except there's IR issues perhaps involved, but just wondering, given they are attached to our courts and that's the work they're doing, if you can update the committee in relation to that situation at the moment.
Look, can I say this in noting that the sheriffs this year are 200 years old. It's their birthday and they do remarkable work, quite seriously.
Sorry, how old?
200.
The
Charter of Justice?
Yes.
Same as the Parliament.
Same as the Parliament, same as the Supreme Court. And of course created by virtue of the Charter. We are obviously aware of and seeking to manage the industrial action which is having an impact across the state, and I acknowledge that. We are seeking and have been seeking to work with the PSA. I underscore the value of the work that those officers do. It is work that does have skill, and it is very important work for the operation of the courts. I might look. There is an acknowledgement that there is pressure arising and that there is industrial action underway and a desire to see it resolved. I really don't know, looking to Mr. Daith, whether there is much that I'd be wanting to add in my evidence at this point.
I don't think so, unless there's something further we can.
I suppose the further part of the question really is, as what Mr. Tipple went to, that it is having an impact.
Yep.
What sort of backup plans does the court system? What are you relying on? As well?
So we are keen to resolve the dispute. Full stop. In terms of backup for the courts, a lot of work has been done. Some of it on an outsourced basis, some of it by use of other staffing resources. To this point, we've been able to manage those pressure points. We are conscious of the security issues where there are impacts on listing arrangements in the interests of security and the ordering of the courts. We undertake that work, but it is causing stress and it is causing strain, and we have hitherto been able to manage with the resources that we have, partly on an outsourced basis, Mr. Dave.
There is, yes, that's,
Yeah.
that's correct.
Yep.
And so with that, when you say outsourcing, is that referring to private security firms as well?
Yes.
Are there places?
On a very limited basis.
Very limited. I was going to ask, which regions are we talking about where we've had to do that?
So I should just clarify that outsourced basis exists in most places anyway, in addition to the sworn sheriff officers. So it's not, but obviously it has been increased because of this particular action. The number of regions, all regions are affected by the work bans that are in place and the industrial action that's occurring.
Are there any regions in particular where you've had to increase the use of private security because of the current dispute?
Yes, but I have to take on notice exactly what that increase, quantifying that increase in each of those locations.
Yeah, I think the answer to the question is yes. Well, in terms of the specifics by region, we would be happy to provide that on notice.
Thank you. Ms. Hitter, I'm just wondering whether you have any knowledge about the increase, if any, of legal aid services in relation to the newer introduced bail laws that have come in, and whether you have a lens on that.
I would need to take that on notice, Higginson, in terms of numbers. Yeah. Of course, we service the courts, provide legal aid to young people and to adults before the courts in relation to bail. But the actual numbers and whether there's been any particular increase in those numbers following the changes to the legislation, I would need to take on notice.
Thank you. Has there been, more just culturally, has there been any discussion amongst legal aid lawyer teams in different regions, but obviously particularly around Moree and other places?
Obviously, policy setting is a matter for government, and we provide services as needed. As people present to courts, we provide those services, and we continue to do that through changes to legislation.
Have there been any, does legal aid and the ALS have a dialogue?
We do. We do talk together quite often, particularly at a local level. We need to work closely together because we are providing services to the same communities often, and in relation to things like where there is a conflict or there are more than one party that needs to be represented, we would be working together with the ALS to make sure that everybody gets representation that needs it.
Thank you. Thank you. Perhaps for the, it might be you, Mr. McKnight, but I suppose I'm interested in understanding a bit more about the consultation with the ALS and the AG with the bail reforms. The AG gave evidence earlier that there was some kind of consultation with the ALS, and he referred to Carly Warner in particular. Is there evidence you can provide about, what that consultation involved? Any feedback at that point?
So that consultation happened at a very high level indeed. Did you want to take that?
I can help in so much as I was a part of, and I would stress, Ms. Higginson, because in this, in talking about these issues, there was discussion in that sense, consultation. I think the AG and those involved would not purport that it was co-design or shared decision making or anything close to it. It was there were discussions to which I was a party with Simon Draper, the Secretary of the Premier's Department, Kate Boyd, the Secretary of the Cabinet Office, with, as I've said, with Carly Warner and John Mahar from APSEC. And they were consultation, but I would not state that it was it was limited consultation, but nevertheless it did occur, and it occurred in the context of the changes to bail, as well as in the context of other regional crime issues which were playing out at that time.
Can I ask about, the Attorney-General spoke this morning about the investment made, or the funding, sorry, I think he's referred to it as increased funding into justice reinvestment.
Yeah.
Could you tell the committee about, what that looks like in terms of the programs? Is there? Thank you, Ms. Campbell.
Ms. Campbell, I think, is the person. Thanks.
Yeah, so I think the attorney talked about the $9.8 million investment that was made by the New South Wales government in June 2023. There was also a contribution of $9.4 million from Paul Ramsay Foundation. In January 2024, we launched a grant to expend the remaining $7.5 million. So $2.5 million last year went to Just Reinvest in Kempsey and Nowra, and we undertook a two-stage process. So from the 23rd of January till the 18th of March, we did an EOI, and we also engaged Thiruwi, an independent Aboriginal-led consulting firm, to really support some of the ACOs in being able to apply for these grants. And it closed on the 13th of May. We did prioritise projects, 3 projects led by ACOs, and 4 were successful, 3 of which were Aboriginal. So that was Just Reinvest in Mount Druitt, the Toomala Local Aboriginal Land Council, Yana Nuglee, which is a local Aboriginal Land Council in the Clarence Valley, and Walu Aboriginal Corporation in the Bathurst area. So all the funds have now been, I think we're signing up contracts as we speak.
And so in terms of the direct investment into Moree, that's obviously that wasn't covered in any of that. So
no, that's correct. There was already a pre-existing Paul Ramsay Justice Reinvestment project in Moree, so that's now working with Premier's Department and the Mayor and other local stakeholders to ensure that it is really looking at kind of prevention, early intervention, so that young people don't obviously need to be bailed, get supports earlier. So.
I know that I've been told this is a matter for the police, but have you heard at all anything about the NRL stuff and how that's going? Like, has there been any kind of discussion about what that mentoring program is? It in existence? Like, are you aware that it's a program happening or not?
I'm not aware. I know it is happening, but I'm not sure of the details, but happy to take that on notice. I think it's being led by the Premier's Department.
Oh, okay.
Yeah.
Yeah, it was, I've been told in each estimate it's someone else, okay. And nobody's actually said where it is, so.
I'm happy to come back and give you information.
Thank you. If that's the case, I would be really interested in knowing a bit of detail about the NRL program and, in particular, how many children, if any, have kind of signed into that program, which NRL stars are involved, and how many times, if any, those NRL stars have been to Moree, and what the kind of aspects of that program mean. Is it, is it a phone contact? Is it a Zoom contact? How do these young people connect with these superstars that they've been apparently, connected to? I'd be very grateful. Thank you. I might just have a break. Are you ready to take over? Thank you.
I actually might just follow on. Thank you very much again. But yeah, I might just follow on in relation to the Justice Reinvest. So just to clarify, in the government's announcement back in March, it was $12.9 million to fund a new range of services, and they said $7.5 million in Justice Reinvest. That $7.5 million are they the grants that you just referred to?
Correct.
So there's no new money that was going into Moree?
No.
No.
Other than what's going through the
Paul
recent...
Ramsey.
No, separate to that, there's funding for the bail, and I think they're out on a grants round at the moment to look at wraparound supports as well.
But that's not part of the
That's
Justice
separate.
Reinvest?
It's separate.
That's really interesting.
Yeah, it's very misleading. And I'm not familiar with the Paul Ramsey program in Moree, and that's all philanthropic funding?
Correct.
Yeah. Could you just outline what that involves?
I think you may be familiar with the Marinuka program out at Burke. So that's
Very
been
good
operating
program.
for a number of years. So it operates quite differently in different communities. So there's a lot of co-design. It's really looking at how services are working together on the ground to address the particular issues. So it'll look different in each community. And they raise money from a whole range of sources. They do really focus on the data and the outcomes and the evidence. And I think they've obviously started in a number of locations in New South Wales. I'm just trying to find my notes
And I'm
here.
mindful that they are an independent.
Yes, they are. They are. And they certainly have been a strong advocate of this approach. And that was part of the reason that the New South Wales government funded it. Let me just see.
So I have Justice Reinvestment sites in Burke, in Mount Druitt and Moree, funded out of philanthropy.
Yeah. Just seeing if I've got anything more.
That's okay.
So with the Kempsey and Nowra Justice Reinvestment sites, both sites have commenced understanding, monitoring, evaluation and learning initiatives. Each site's data team meet frequently, including support from the University of Southern Queensland and Just Reinvest New South Wales head office. Paul Ramsey Foundation has engaged Taylor Fry to undertake a quasi-experimental evaluation for both sites. Kempsey and Nowra have commenced discussions with Just Reinvest New South Wales to transition to Aboriginal community controlled establishments. This includes immediate plans for Just Reinvest to subcontract a portion of their contract. Kempsey hosted the Learning the Macleay Forum in June 24 with representatives from government, non-government agencies to engage in community-led systems, change to address local issues. Kempsey continues to facilitate the cross-sector leadership group. The next meeting's this month, and initial development of the theory of change frameworks have commenced in both of those sites. The Marinuka, if you wanted a little update on that, so that was initiated in 2013 in Burke by Just Reinvest New South Wales, and then it was auspiced by the Aboriginal Legal Centre and the Burke Tribal Council. It was actually the first Aboriginal led based model of justice reinvestment in New South Wales. There's quite a lot of detail here in terms of some of the previous funding, but it's not as contemporary as the 9.8 million.
And just the other final part is that the Paul Ramsey Foundation is looking at, did you say the Taylor Fry?
Yes, correct.
And the evaluation that's being done, will that then be given to government?
I would imagine it would be shared with government because it's sort of a partnership.
And we do have a good relationship with the Paul Ramsey Foundation, and there is very tight coordination. So it is a very credible partner.
And do you have a time frame of when that evaluation will commence or be completed?
I think because they're still establishing, particularly the Kempsey and Nowra, it'll probably not be quick, I wouldn't have thought, because you'd want to actually look at, does this sort of approach actually lead to sustained outcomes?
Yeah, that's fine. Thank you. While I'm on that announcement, I just wanted to get a better understanding, particularly around the place-based responses. and who would be responsible for the rollout? So obviously the additional jurisdictions, Judicial Resources AG. The youth Aboriginal people would be linked to Indigenous organisations, elders, cultural and family support from their own communities, and with skilled, qualified, trained and consistent staff on site 24/7 providing child safe care. And this has come from the press release. Would that be something that's managed through DCJ?
Youth Justice, I believe.
Youth Justice.
Which is part of DCJ, as you know.
Yep. And then the out-of-home care activities, which is the partnership with Moree Plains Shire Council, Aboriginal control organisations.
Probably DCJ.
Look, can I say DCJ? It's definitely DCJ. Youth Justice, or Paul O'Reilly,
yep.
Who gave evidence yesterday, is a key person in working on the ground in Moree, but there are different parts of DCJ that are involved.
So I'm happy for you to take on notice, but if I could get a better understanding of what those after-hours activities are, and if there's a funding allocation to
Yes.
that and grants process.
Happy to take that on notice.
I can probably just add a little bit. I'm just looking at the notes. There's a small grants program which is administered by the Premier's Department. 1 million of the funding invested into the targeted response in Moree has been allocated to new small grants program to deliver more after-hour activities, which has seen funding already been allocated to services in the area, which includes PCYC awarded $314,000 to expand the Unites program to an additional 2 evenings each week on a Thursday and Saturday, and that program is really aimed at helping young people build positive friendships and deeper connection to their community and culture. The Moree Sports, Health, Arts and Education Academy was awarded $152,000 to deliver specialised youth programs on Friday and Saturday evening each week with staff support until 2 a.m. in the morning. And Miuwe Bire was awarded $282,000 to improve and expand Street Beat so that it operates until 12 a.m. on Monday to Wednesday and until 2 a.m. on Thursday to Sunday evenings each week. Mm-hmm. And the police force have also established a local community safety precinct committee to improve local safety responses, increase community knowledge and awareness of crime prevention measures and improve community crime prevention planning. The New South Wales Police Force will also be working with Moree Council to undertake safety audits and risk assessments, support businesses and local residents to improve personal and property security and identify crime prevention activities. They continue the police force operations in the Moree area to meet community needs. This includes continuing to surge operational resources. In addition to the Youth Command, we'll continue Operation Youth Safe, which combines education and early intervention to at-risk children.
And that's all out of the 1 million small grants.
Correct.
From the Premier's budget.
Yeah.
The other thing to clarify, so in the release it says 13.4 million for a targeted response, which included a new 8.57 million for the bail accommodation. Is that additional to the 13.4 or within the 13.4?
My understanding it's within the 13.4, but if I'm wrong, I'll come back.
Okay, that's fine. And then I assume that 1 million would also be part of that 13.4. And then just in relation to the 12.9 under the broader regional crime prevention initiatives, where it states the rollout of the 7.5 million in Just Reinvest, is that within the 12.9 or new money?
I'm not sure where the 12 point, I haven't got the media release, but the 9.8 was previously announced back in 2023. Only 2.5 million was allocated in that financial year.
Yep.
The other 7.5 million, independent of what's happening in Moree, occurred this year, so I suspect it's separate to that.
Okay, thank you. In relation to crime figures for Moree, is there any information being collated, or has it been collated over the last 6 months or since the sort of the March announcement?
probably need to take that on notice. I'm sure there is a lot of data.
There would be data, but we would need to take it on notice.
And then if you can look, yes, if it's been collated since that announcement, and also what categories are being, types of crime that are being examined and I suppose tracked. Might actually go to just to clarify in relation to the electronic monitoring this morning. I just want to clarify the time frame of when that will be rolled out. Did you say the end of September or October, or was the?
It is imminent. October is anticipated.
Yes.
That end of October or beginning?
I had thought early, but I did not want to. I want to be faithful in what my evidence.
Early October is our aim.
And has a budget been set?
The funding for electronic monitoring is anticipated to be part of the 45 million set aside for justice initiatives at the moment, but we are rolling the program out, so it's we need to monitor the budget to see if that's adequate.
And so it's within the 45 million, but you don't know how much you have allocated for electronic monitoring?
It will be, as with many things, so it's, colleagues, correct me if I'm wrong here, but as with any initiative, we are trying to predict the behaviour of the courts and the manner in which courts make orders. It is very difficult with precision to forecast what the demand might be, and in that sense, particularly during the establishment phase. So there is an allocation of funds. It would be very difficult to specify what the demand would be and therefore to put a precise cost on it.
Okay.
That will become clearer over time after we see the number of orders made by the court that require the EM.
So at this stage, it's fair to say that no new devices have been purchased. You're just working within the existing parameters.
So that is of itself, and again, looking to my colleagues who will know the detail better than me, but these devices are used by corrective services. They are effectively leased. They are not purchased.
Yep.
And the devices are unique in that they're devices which potentially have two components to them. One is for the alleged perpetrator or the person on.
Yeah, and I think in this case, there's a existing stock of electronic monitoring devices that cover a range of situations where they're currently used. So they're used for domestic violence cases and parole matters. They're also used in intensive corrections orders and home detention type situations. There are some situations where they're used for inmates who are on leave from prison. So there is an existing stock. Whether that stock is enough or not to cover the new cases that will come along through this, a little bit unclear, but that stock can flex. Yep. We don't anticipate significant problems in having enough devices on hand.
And my understanding is it's an agile stock in the sense that it is there is a perpetrator device and there is also a victim. In some cases, there is a victim device.
There are victims' devices at the moment in the parole situation.
Yep.
Thank you. I might turn to a couple of things that have been outlined in the budget papers, our plan for New South Wales, page 35, around for police and justice. The 66.9 million to divert young people away from police and courts through community programs. Can you outline what those programs are and if there are any new programs?
Yes, I may. Right, yeah, I'm happy to do so. So the 6.9 for 24 to 25 year over the forward years for youth justice diversion responses include Youth on Track, which helps young people reduce their risk of offending, the Bail and Accommodation Support Service, the Broadmeadow Children's Court Project, which provides wraparound supports to young people presenting to the court, A Place to Go, the Rural Residential Rehabilitation Adolescent Alcohol and Other Drug Service, provision of legal services to Aboriginal people in detention, the Short-Term Remand Project pilot, Short-Term Remand pilot, which provides accommodation to young people on remand, and domestic and family violence therapy.
And none of those are new.
They are existing programs.
Yes.
Yeah.
In relation to the 40.3 million for legal officers in the Office of the DPP, I just wanted to know how many staff are currently employed, and is any of that money for additional, for new staff?
Thank you. I'll take that. Thank you for the question, but before I do that, Mr. Chair, I was hoping to make a brief statement, if with permission of the Chair.
Yeah, sure. Could you just pull the mic a little closer, please?
Sure.
So we can hear you.
Thank you. Is it suitable that I make that now or answer the question first?
I think answer the question first.
Sure, thank you. Our current staffing levels are 988 full-time equivalent staff. As a result of the recent extra funding in the budget, we have been able to fund another 63 positions.
Okay. And
the
oh yes, sorry, the
going to make a statement.
Thank you. I thank the members of the committee for your interest and engagement with the work of the Office of the Director of Public Prosecutions, the peak prosecution agency for New South Wales. At the outset, I would like to stress that the ODPP and I, as the Director, embrace the constitutional importance of our being accountable to the Parliament. Like the other prosecution agencies of Australia, the Independent New South Wales ODPP was created in response to the political corruption scandals of the 1970s and 1980s, when it was recognised that there was an inherent conflict of interest in having prosecutions conducted by Attorneys General. A key aspect of the proper functioning of the ODPP is the independence of the exercise of prosecutorial discretion. Decisions by my office about criminal prosecutions are to be made free of influence by political, individual, or other sectional interests. Contemporary political theory recognises the importance of an independent prosecution agency as a key indicator of the health of a democracy and the maturity of the rule of law in any given jurisdiction. It is critical to our democracy and integral to the rule of law in New South Wales that our systems of government and governance do not countenance direct interference in the prosecutorial discretion. It is not only direct interference that undermines trust in government and the legal system. The perception that the independence of the ODPP has been impacted or compromised is equally damaging. Importantly, prosecutorial discretion is not free from oversight. First, every decision to proceed with a criminal charge is, axiomatically and appropriately, reviewed by the judiciary in the form of a trial, and my office's decisions are rigorously overseen by the courts. Secondly, the ODPP is accountable to the Parliament and to the Attorney-General through the statutory obligation to prepare and furnish annual reports, and the requirement under the DPP Act that the Director must consult with the Attorney-General when requested. Third, there is the Victims' Right of Review, with its legislative foundation in the Victims' Right and Support Act 2013, which requires the ODPP to review its decision-making on request by a victim. Fourth, all ODPP staff are accountable to the general public, victims of crime, accused persons and other stakeholders in the criminal justice system through the application of the prosecution guidelines of New South Wales, which were developed after broad community consultation. The prosecution guidelines are public and they are published on the ODPP website. They prescribe the two main considerations for the exercise of the discretion whether to prosecute, namely the requirement that a prosecution enjoys reasonable prospects of conviction and that it is in the public interest. The prosecution guidelines are the only policy applied in determining whether to institute or maintain a prosecution in New South Wales. Finally, so far as prosecution policy is concerned, it is legitimate that society may settle matters of policy through the political system with appropriate parliamentary control. This is another important aspect of the rule of law, transparent law reform processes where issues of legal policy can and should be discussed. There are various established and effective law reform bodies, which include the state and federal law reform commissions, working parties convened by the Department of Communities and Justice, the work of the New South Wales Bureau of Crime Statistics and Research, and broader academic research commissioned by the government, all of which is informed by inclusive and respectful discussion. Thank you, Mr. Chair.
Thank you. Questions?
Yes. I'll go back to the our plan for New South Wales. So the $38.2 million that's delivering services to improve improvements across the justice portfolio, upgrading around cyber security. Now, it's only mentioned New South Wales Trustee and Guardians, NCAT, and also Youth Justice. Any reason why those three are mentioned, or is it across all of DCJ and agencies to improve cyber security or prevent cyber security issues?
I will need to take that on notice, Ms. McGarren-Jones.
Okay.
I believe it would be broader, but I am speculating I should take that on notice.
And then also just to check whether it is in response to a particular issue or just routine because of upgrades that IT might be needed.
Detail what the work is.
Oh no, I've still got, sorry, beg your pardon.
I'm happy to. So if you want to go. Yep. In relation to court staff, particularly in regional areas, are there any issues in recruiting staff to court staff in particular to rural and regional areas?
So as I travel around the state and talk to various court staff, many of them are actually recruited locally. There are people embedded in communities who have grown up in those communities. I think in terms of registries in the courts, there are many staff who are recruited locally who have very long service in the courts. I'm aware of recruitment challenges across a number of areas in DCJ at the moment, which are well known. I've not at any point had concerns raised about recruitment of court staff. Mr. Dathan may be able to supplement that.
I've no specific concerns. Other than we operate in the same employment market as others, and there's no particular concerns that I'm aware of.
Okay. With respect to judicial officers, is there any difficulty around managing work health and safety issues, and particularly around, I suppose, exposure to trauma or cases that they may need to deal with?
The answer to that question is yes, and particularly as the work of the courts changes over time, so that the local court, as I think this committee will appreciate, undertakes an immense amount of work with domestic and family violence, and that can be work which is very challenging for judicial officers. Similarly, the work at the district court, which with the amount of children's sexual offence trials which occur there, that similarly is difficult work. There is dialogue that occurs constantly between the department and the heads of jurisdiction about programs and initiatives, and there is no point at which you ever have these matters covered off. They are the subject of constant review in terms of what we're doing in the courts and the initiatives that we have stood up, both in the local court, where there's been discussion and activity over the last year, and also the district court. I could probably usefully take that on notice, and I'm happy to specify what the initiatives are.
That's great, thank you.
Ms. Mahalik.
Oh, thank you. Thank you, Chair. I just want to, if I could ask Mr. Tidball, just in relation to case law, that's obviously administered by your department? Online? Or case law?
Yes, it would.
Yes, it is, yes.
It's Mr.
Okay.
Daith's area, yeah.
I noticed that R versus Martinez, which was handed down on the 5th of December 23, it's been removed and is listed as restricted on the case law website as of the 29th of August. Is that right? Could you take that on notice?
I'm very happy to take that on
Yep.
notice.
And also another case, R versus Smith, handed down on the 27th of February 2024, was also removed and listed as restricted on the case law website on the 23rd of August 24. That's a Whitford case, the other one's a Newlands case. And I note, if I may ask you, the website says that some decisions are either temporarily unavailable due to further proceedings or permanently restricted from publications on New South Wales case law. Could you let me know which one is the case? What's the reasoning behind these two cases?
Happy to take that on
No
notice.
longer being restricted?
Of course.
Okay, you could take that on notice. Thank you. Can I also ask Ms. Dowling, just a quick question. In March, you indicated that you're undertaking a review of 400 plus sexual assault cases.
Yes.
Is there any updates to that? Is that review finalised?
It's almost finalised.
Okay. Well, I take it none of that will become public knowledge. It's only for the purposes within your DPP, the review.
Oh no, there will be a public report that will be published.
There
on
will
my
be a
website.
public report.
Yeah.
Okay, there will be a public report being published. Have any? Obviously, it's being handled by the senior Crown prosecutors. Is that right? Is that? I'm just trying to understand who's sort of managing the.
So, if I may just
Sure.
give you a bit of a synopsis. The review commenced following, as you say, in March, following initial planning and preparation phase. The scope of the review is all adult sexual assault trials listed between the 1st of April and the 31st of December 2024, but excluding child sexual assault matters. So it was 330 sexual assault.
Sorry, Ms. Dowling, can I just get that date again? 1st of April
to the 31st of December. So it's matters listed for trial in this year. 330 adult sexual assault prosecutions have been reviewed, but there's a final outcome pending in 11 matters, so it's not quite finished yet. The reviewers were tasked with considering whether the decision to prosecute, including the maintenance of the prosecution, was in accordance with the prosecution guidelines, with particular regard to issues that frequently arise in sexual assault prosecutions, including the impact of intoxication, the relationship between the accused person and the complainant, proof of complainant's lack of consent, and proof of the accused person's knowledge thereof. The review adopted the principles of the New South Wales Government internal audit policy, which ensures high standards of independence and objectivity. The key controls adopted to ensure that objectivity were a clear scope and outline of responsibilities, which are fully documented and communicated to reviewers. The documents utilised in the review have been recorded for transparency. The reviewers were all very experienced Crown prosecutors and deputy senior Crown prosecutors who were selected by the senior Crown prosecutor. The reviewers were independent from the prosecution team, each coming from an office different to that where the prosecution was commenced. Any conflicts of interest were managed and fully documented. The application of the prosecution guidelines itself acted as a further control on the decision-making of the reviewer. There were multiple tiers of review, with matters referred to directors' chambers for determination when potential issues were identified, as well as to senior counsel for further review when required. And there will be a final external academic review of the report before it is published.
Okay, and when do you roughly think it'll be published?
The current timeline is we're hoping to send it for academic review in mid-October, and depending on the availability of the reviewer, hoping for finalisation of the report late October or early November.
As a result of the review, have any cases been discontinued?
Yes. So the review has demonstrated a consistently high standard of legal analysis by the prosecution teams in an area of the law that is complex, and no systemic issues have been identified, but opportunities for improvement have been noted. No unwritten policies have been identified. There have been, there have been, of the 330 matters, there have been 15 matters terminated. 8 were terminated on evidentiary grounds and 7 were terminated on either discretionary grounds or a combination of discretionary and evidentiary grounds.
So discretionary and evidentiary, or
that's right.
one or the other.
I do want to stress that of the 8 matters that were terminated on evidentiary grounds, it is my understanding that it is likely that these matters would have been identified in the normal course of the prosecution, because some of these matters were many months out from trial. Also of relevance is...
Sorry, how do you come to that understanding? Is that the advice that you've been given, or...?
Because in the life of a prosecution, the viability of the prosecution is constantly under review. And for example, and this is just a hypothetical example, if a matter is listed for trial in November and it's being reviewed in April, it is likely that between April and November, a very detailed review of that would have been taken in the normal course. That the Crown prosecutor who is going to be running that matter, when in preparation for the matter, would have identified the problems with it and sent it up.
So that's a normal number for every year. If you have 300 or so cases, that around 15 would be discontinued. That's nothing.
We have a number that are discontinued every year, and I'm optimistic to be able to have that have a useful analogue contained in the report, but extracting that data from our systems is very, very time consuming. It's in fact it's a manual process. So the short answer to your question is yes. There are matters that are discontinued all the time during the life of the prosecution. It is also relevant to note that in all of the ones that were discontinued, I withdraw that. There were 10 matters that have been identified as non-compliant with the prosecution guidelines, but not all of those have been discontinued. In all of those matters, late brief service was a contributing factor. So that means that the time for certification of those charges was much truncated due to the late receipt of the brief, and that results in intense time pressures for the certifier at the ODPP.
And that would have been the only prosecutorial guidelines that were breached in that instance, but not of the fault of...
I'm not sure I understand.
Well, no, I'm just trying to understand. You're saying that, or sorry, not breached, but I should say not compliant with the prosecutorial guidelines. That's...
My point is that in all of those matters there was less time than is properly...
Yes, that you would normally expect under those
as
guidelines.
Necessary to make those complex decisions.
Okay. Ms Dowling, were you aware that the R versus Martinez case and the R versus Smith case are no longer available on the case law website?
I became aware of that when it was reported in the Telegraph.
Okay. Okay, that's all.
Thank you.
Thank you. Mr. Tipple, I just wanted to ask about whether you're aware, or maybe it might be Mr. McKnight, whether any work is happening in the department about a post-conviction review system in New South Wales. I know I've spoken with the attorney at previous estimates, and I'm fairly certain he assured me there was some work happening, but I would like to know if there is, and if so, if there's an update on that work.
We've provided the attorney advice on that question in the past. There's no current work going on that matter.
Thank you. And what question was that?
The issue of post-conviction review, the issue you raised.
As in, I suppose
I might have lost the thread of your question.
Yeah, no. So that's very helpful. So I suppose what I'm trying to ask is the only work, so it sounds like the only work in the department around a post-conviction review process was in response to my question. Is that right? Sorry. This is.
You're testing my memory. I don't
I'm
think
not
that's
trying to trick you.
The case. There was advice provided to the AG about that matter. I'm not sure whether that was prompted by your question or prompted by other stakeholders raising questions, but the advice has been provided. As I say, there's no current work going on that question.
So I suppose what I'm trying to understand then is what is not necessarily the contents, but what was the parameters of that advice? Was it about whether there should be a system, whether there could be, whether we, in response to looking at other post-conviction review systems through other jurisdictions, or?
Look, I must say I can't recall the detail of the advice, and I'm not sure that I would canvass the content of advice we provide to government anyway in this forum. Ms. Higginson, I mean, policy matters, as you know.
So was it provided to the government or to the Attorney General?
To the Attorney.
To the Attorney.
Yeah.
And is that, is it something you can take on notice, whether or not you can provide any detail around? I'm just curious. I mean, I asked the Attorney and I just haven't had the opportunity to follow up by letter. And I know there's a lot of stakeholders out there, and I think quite a few of us assumed that there was work happening in the department.
I'm happy to take that question on notice.
Thank you. I am interested in, what work has been done, and what advice has been provided about New South Wales progressing.
Yeah, I think I understand the question. I would say there are quite extensive provisions under the existing Criminal Appeal and Review Act for convictions to be considered by courts post conviction.
I think
those are different provisions than exist in other states.
I think the concern, and I think we've had this discussed in this forum, is that they're completely archaic, antiquated, and not really fit for purpose. And we would just look at the Kathleen Folbig scenario to evidence that concern. And I think that's where the discussion commenced around a post-conviction review system, and that New South Wales is, in fact, a bit behind many other jurisdictions. That was I understood that was what the attorney was looking into on those bases. And yes, he maintained that we do have provisions. So I'd be very grateful if we could look at it. And if you are able to provide the committee some advice, that would be very helpful. I just would like to know, and I'm interested in the Judicial Commission of New South Wales. I'm not sure who's best placed to answer that. I just have a few questions around what is the constitution of that body?
Right. It is established under statute?
It's established under the Judicial Commissions Act, yes. It is constituted by the heads of bench across the court system. When it sits in conduct matters, it is augmented by community representatives.
Its president is the Chief Justice.
And how often does it meet, or does it only meet for conduct matters, or I'm just curious about the way it functions?
I don't know. It is an independently constituted body that obviously has responsibility for not just judicial conduct but also judicial training, and those are issues that the judiciary quite properly jealously guard as matters of their independence. Happy to take on notice any detailed questions that you have.
It does have its own chief executive,
Yes.
Una Doyle.
Yes.
Yeah.
It's very active.
Very active.
Yeah.
And
its work isn't just purely, it doesn't just work within the realm of conduct. It has a very active education program.
Yes, yeah.
But I'm reluctant to speak for it because it does.
Writes
Okay.
bench books.
Own piece of legislation.
No, I'm aware of that. I think what I'm kind of interested in is, how often the actual judicial officers meet in their capacity as the Judicial Commission.
Yeah, I don't think we can comment on that.
And then
regularly, but I think we'll have to take that on notice in terms of the time.
And is there any, do they have minuted meetings or do they just do their own thing? I understand that they are a statutory independent body.
It has the commission.
The commission is the jurisdiction which is respectively.
Sorry, I didn't hear a word of that.
I was
okay, sorry.
Some information.
Look, I think to be very direct with you, we haven't come here with briefing material.
No,
haven't
fair
assist
yes.
in any way. I think beyond that, we're probably starting to speculate, which is not helpful to the
Not
committee.
helpful, I understand, and dangerous territory perhaps. One thing I would ask though, and you may know the answer to this, is if there is a conduct matter and it's determined, what does somebody do if they think the outcome of the determination is not the right determination? Where would, say, a senior counsel who has made a complaint about a judge or something, and then they're not content with the outcome, is there anywhere for them to go or nowhere for them to go?
Again, I refer to my previous response. I think we would need to take that on notice.
Thank you. I'd be really grateful. Thank you. Just understanding if there is any final avenues of appeal. Can we just go back to now the matter that I spoke a lot about with the attorney earlier, and in terms of closing the gap and the particular target and the incarceration target and the fact that the data is not good insofar as I think you also expressed, Mr. Tibble, here that the numbers have increased in terms of...
I was talking about target 10, I think
target
specifically,
10.
and youth, which I acknowledge largely due to the growth in remand.
Yes,
numbers.
yes. So just on that, with the remand, you provided evidence earlier that I think there was 13,009
Correct.
people on remand.
Yes.
56% sentenced prisoners, 43% held on remand.
Yes.
I'm interested in what is the percentage of that 43% held on remand that is First Nations people?
Yes, I do, I believe, have that. So
I'm happy for you to give me that break in any form that you want to give.
Look, so of the total 13,009, without breaking, so I've indicated 50%, 56% are sentenced and 43% are on remand. Of that total cohort of the population of 13,009, approximately 31.5% are Aboriginal or Torres Strait Islander.
Right, and what about the young people? How have you got that number in terms of when I say young people, under 18 years of age, and then under 14 is?
I did absolutely have that number here.
Thank you.
And I'm searching for it. Yeah, so thank you. So look, The piece of paper I had this morning was today. I seem to have lost that piece of paper.
Yes.
But as of the 30th of June,
Yep.
there were 145 Aboriginal young people in detention,
Yep.
which is constitutes 58.7% of the total youth detention population. Currently, 78.6% of Aboriginal young people in detention are on remand. In June 2024, there were 114 Aboriginal young people on remand, up 35 to 43% since June 2023. And just in terms of offence breakdown, I can also give you that if you want to know what.
Sorry, it was an increase of what? 30?
35.
35.
Or 43, but 35 people or 43%.
43% increase in the 12 months.
On remand, yes.
43% increase. That's quite an alarming number, Mr. Tibor.
Yeah, and just in terms of the drivers for that, they were car theft.
Car theft.
29.8%, and of the increase, and break and enter, 21.1%.
And so sorry, I know my time's up,
No,
but
no,
out
keep
of those, sorry, you were going to give me just some more numbers then?
I'm out of numbers.
You're out of numbers,
Out of
okay.
numbers.
Thank goodness, because they're pretty bad, the ones that we have.
Yeah.
But just out of those, what is the youngest person that's held on remand at the moment? Or as of the numbers you have?
We can attempt to, I suspect.
Yeah, could you please try
somewhere.
and get me that in the next
Yes.
session?
Bear
Thank
in
you.
mind, it can shift
I know.
by the day.
I know. Thank you. You can keep going. No, it's fine. 43% increase of young people, First Nations, incarcerated in 12 months. Thank you. We're doing great, aren't we?
I might move on to some items in the budget paper. So, budget paper number 3, pages 2-11, in regards to the expansion upgrade of the audiovisual link facilities. I'm interested to know how many courts and tribunal rooms currently have facilities available.
I don't know that I've got the exact. Don't know the number with me.
We need to take that on notice.
I think.
Could you also take that on notice as to locations?
Yes.
Breakdown, obviously metro and regional. In relation to the announcement that's been made, how many courts and tribunals will be upgraded with that 18 million?
We will need to take that also on notice.
Okay. In the budget papers, it's actually allocated 18 million as a total cost. Over the 4-year period, 27-28, only 14 million has been allocated. Does that mean that it's expected to take longer or go beyond 2028? And if so, or?
So the AVL program is effectively an ongoing and rolling program because the equipment itself, of course, gets to the end of its useful life and needs to be replaced. And so the AVL program, I think it's the budgets are for a particular forward period, of course, but the AVL program itself will need to continue to seek funding into future years to replace equipment that's already in place in courts.
The other thing, are these changes, the AV changes, required to implement the new DV laws?
In relation to the change from registrars bail to magistrates? Yes.
Yep. So what impact will it have if it's going to take over the next 4 years?
So there is separate capital funding for, which I think was canvassed earlier in the proceedings, in relation to AVL upgrades for police locations.
And how much is that?
For $4 million.
Yep.
The drug court expansion, where where is that up to as to what will be rolled out this year and over the forward estimates?
The drug court, and I'll ask Mr. Daith to assist me, but it is ratcheting up in Sydney in terms of LGAs. I believe that this was covered in evidence at the last estimates. My understanding is it is on schedule, but we can provide to you the list of LGAs to which it's now been expanded.
Yep. And then, so obviously the locations and if they're on track.
Yes.
And when they're expected to be completely rolled out.
Yes.
Just in relation to Campbelltown Court, now there's been previous media reports in relation to inadequate bathrooms and also that some felt that this site wasn't secure, particularly around where offenders needed to use the same bathrooms, also entrance as victims. And my question is there anything in the budget or any funds allocated in the budget for upgrades of Campbelltown Hospital?
Court,
sorry.
No.
Health's next week.
No. Not that I specifically. No.
Not specifically.
No.
Okay. Is anything being done in relation to ensuring that, I'm also mindful there's the children's court there as well, but ensuring that victims and perpetrators aren't having to share bathrooms or doorways?
I have no knowledge of difficulties. It's not to say that they do not exist. I would, however, need to take that on notice.
That's fine. And then also, if you could also provide information about accessible bathrooms at the court.
Right.
And whether they're available and
Yep.
if they're on each floor. Do you want to, are you ready?
Yeah, what am I doing? What am I doing? Have you done? If I might jump in and perhaps I might have a few questions for you, Dr. Cockayne, if that's okay. Have you done any policy or research work on connections between surrogacy and modern slavery?
Yes.
And what has that research or policy work demonstrated as potential issues?
So I've received several representations about the connection between modern slavery risks and commercial surrogacy. In February of this year, I wrote to Mr. Greenwich to raise concerns regarding Schedule 19 of the Equality Legislation Amendment brackets LGBTIQA plus brackets Bill 2023. I believe that's the correct full name of the bill, which would, as you know, amend the Surrogacy Act. And I raised three specific concerns. First, that poorly regulated commercial surrogacy arrangements may produce modern slavery in some circumstances. Secondly, that as it was then drafted, so I'm going back to February this year, as it was then drafted, Schedule 19 risked feeding a race to the bottom, encouraging New South Wales residents to use poorly regulated commercial surrogacy arrangements despite associated modern slavery risks. And thirdly, that New South Wales residents may end up being exposed to criminal liability for violation of certain Commonwealth and New South Wales offences identified in Schedule 2 of the Modern Slavery Act of 2018, or indeed liability for breaching modern slavery laws overseas.
And what are those modern slavery risks?
So the first is that I should emphasise that surrogacy, whether commercial or altruistic, can be organised in a manner that does ensure that it's free of coercion and consistent with the rights of all parties. However, when poorly regulated, commercial surrogacy may in some circumstances create several different risks relating to modern slavery. In 2018, the United Nations Special Rapporteur on the Sale and Sexual Exploitation of Children flagged concerns around abusive practices in some international commercial surrogacy arrangements. In some such arrangements, this can amount to the sale of children, and the Special Rapporteur made several recommendations, including the introduction of various safeguards to prevent the sale of children. Just to give this a little bit of context, This is not a purely abstract or hypothetical concern.
Mhm.
In September 2023, so about a year ago, authorities in Greece raided the Mediterranean Fertility Institute and charged all its staff members with participation in human trafficking after an investigation uncovered use of brokers, fraud and record falsification to traffic at least 98 women from Ukraine, Moldova, Romania, Albania and Georgia, many of whom became birth mothers at the clinic. They targeted financially vulnerable women. Shockingly, around half of all the clientele for that institute were reportedly Australian. Between 60 and 150 Australian families are thought to have been impacted by this incident. Many lost tens of thousands of dollars, they lost embryos, and of course they lost the expectations of parenthood, so a true tragedy for them. Some were temporarily separated from...
But if I understand you, Dr. Cockayne, their parenthood would have been predicated on the modern slavery of other women from those countries that you mentioned.
It could have been unknowingly to them.
Yes. Oh, yes, I accept that. Yes, 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 yes.
So some of them were also temporarily separated from babies at the clinic due to doubts over parentage and citizenship. And this is, of course, part of what Schedule 19 precisely seeks to address, the uncertainty created around parentage orders. So the policy inputs that we've provided go to identifying those risks and beginning to think about what some potential solutions to those risks might look like.
And are you aware if these risks have been dealt with successfully in policy so that commercial surrogacy is available in any other Australian state or at a Commonwealth level?
Commercial surrogacy is not available in Australia as a matter of policy, as you're probably aware. Obviously, questions of parentage and so on have a complex constitutional implications, and this is a matter, to my knowledge, of ongoing consideration in both, of course, your Parliament and federally.
And since you've done so much work in this area, did you contribute to the... so there was a Legislative Assembly inquiry into, and I'm going to give it the short title, the Equality Bill. Were you part of the preparation of the New South Wales Government response to that inquiry?
As I'm independent of the New South Wales Government, I wasn't part of that process, but I have provided a submission which is on essentially the same terms to the recent Surrogacy Act review.
And did you also contribute to the current review of the New South Wales Surrogacy Act?
That's the one I mean. So.
Oh, right. Okay, so you've contributed to the Surrogacy Act, but not the LA Equality Act review. Thank you very much. And in the terms that you've provided for us now?
More or less, yes.
Yeah. Okay, thank you. How difficult would it be to achieve policy settings to the Surrogacy Act that did not involve risks of exploitation of women in the context of what we call modern slavery?
It would certainly be, would require very careful thought and regulatory design, and it would require consultation with the federal government, I would suggest, because foreign affairs matters would be implicated. One of the ideas that was floated in my correspondence with Mr. Greenwich and the government was the idea of an expert group identifying jurisdictions that meet the standards set out by international experts for effective protections of women and other parties in commercial surrogacy arrangements. The challenge there, of course, is that you then have an expert group, perhaps making recommendations to the attorney or otherwise, that is giving a tick or a cross, in effect, to different jurisdictions for the human rights protections in those jurisdictions. That has obvious foreign affairs implications, and therefore I recommended that conversation be had between the state and federal governments on that matter.
And I imagine if we're looking at international arrangements, there would be perhaps potentially issues with what might we call it, the rigorous nature of people reporting against obligations, and whether we actually had full oversight over what was happening. Because I believe the example that you gave of the clinic in Cyprus, that was originally thought to be a very reputable, high quality clinic, I believe.
In Crete, yes.
Crete, sorry,
Yes.
I apologise. Yes, yes. So
I think those reporting challenges are central to the difficulties of addressing modern slavery in all contexts,
Yes.
in all jurisdictions.
yes, yeah. I suppose a question about is it fair to characterise the essence of slavery as treating human beings as if they are commodities rather than as people?
The definition of slavery, per se, under international law, certainly has the exercise of the powers attached to the rights of ownership as a central thread. That's been recognised, in fact, by the High Court in this country in the Crown and Tang back in 2008.
So the idea that people become tradable commodities, perhaps, is that the essence of it?
Yes, and what we see these days is that doesn't necessarily happen through physical restraint, but through contractual restraint. And that contract might be a employment contract. So that's the form of contract that's relevant, for example, to forced labour offences or debt bondage. It might be a marriage contract. That's the form of contract relevant to forced marriage offences, which have for much of the last 5 years been the most reported form of modern slavery in New South Wales and indeed in Australia. Or indeed, as I mentioned, debt contracts can also be used. And this provides a framework for psychological coercion and control. So there's a lot of overlap also with the coercive control type offences that are now recognised in New South Wales.
Okay, so you could have an overlap situation where you had a marriage that was a forced marriage that had aspects of slavery but also exhibited coercive control.
Indeed. And it's important to understand, I'm just going to go to some other notes here. Just bear with me, please. Ms. Carter, for one moment. That there is a significant overlap with domestic and family and sexual violence offences, and that there has been a recognition in New South Wales law for some time now of that significant overlap between these offences.
Right, okay. Look, there's something, and I'm not a scholar of modern slavery or a scholar of surrogacy. I have read a bit around these issues, just really to inform myself. And I wonder if you were comfortable commenting on this proposition. I have read suggestions that one of the challenges of commercial surrogacy as opposed to altruistic surrogacy is that it can encourage an attitude that what the surrogate is carrying is a commodity that is being bought by the people who are engaging in that surrogacy contract. And to what extent does that then start encouraging an attitudinal shift that we can actually, in certain circumstances, look at people, in this case the child that is to be born, as commodities, and that actually makes it harder then for us to address a whole slavery mindset?
Certainly that issue has been raised by commentators and experts, particularly overseas. I think against that we need to hold also evidence from real life that most parents who are forced into the terrible situation of having to resort to this very complex mechanism in order to realise a dream that they have to be a parent usually have very loving relationships with the children born out of those arrangements. What I see in my own experience is that the objectification tends to attach more to the birth mother, and that is where there is a particular imbalance of power between the birth mother or the surrogate mother and some other intermediary. And the challenge with encouraging offshore commercial surrogacy is that is precisely where the reach of government to regulate that contractual relationship is weaker. So the danger is that by outlawing the practice within Australia, but permitting it overseas, we're actually making it, exposing people in Australia who wish to participate in commercial surrogacy to a greater risk of poor regulation of the commercial relationship into which they're entering.
And are you aware, because slavery is something which impacts everybody around the slave, are you aware of any work that's been done on the impact of siblings of a child born of a surrogate mother with the design that that child will not form a permanent part of that family?
I'm not aware of any such research.
Okay, no, thank you. I thought that you may be. So, in the circumstance that you outlined before, that example that you gave with those women who had been trafficked, is there what's the likelihood, would you say, and I realise it's sort of a piece of string in some ways question, of us being able to effectively reach into Crete or the Ukraine or another country and actually have a very clear understanding of the situation of the women who are engaging, who are being engaged as commercial surrogates?
Well, at one level, it's a similar question that we now ask many commercial actors, whether public or private, to think about their offshore supply chains.
Mm-hmm.
It's a question of offshore due diligence and thinking about whether the ultimate buyer, whether it's a public entity buying computers or, unfortunately in this context, to use the same language, whether it's the counterparty here that's soliciting the surrogacy arrangements, what ability they have to regulate the commercial activity on the other side offshore. Government probably has a role to play there, but traditionally, again, it would be the federal government rather than a state government that, through its consular arm, for example, might be involved in forming an assessment or review of the regulation of a particular sector offshore. So it can be done, but there would need to be careful safeguards and mechanisms in place.
And in your experience, in your role, are we getting better at managing slavery in the supply chains, or it's still a major challenge?
We're getting better slowly, and there's a lot of work going on within New South Wales Government. There's over 400 reporting entities now that are reporting, all government departments, local councils, 10 universities, 8 state-owned corporations. We've been able to furnish them late last year with 200 pages of guidance on how to manage those risks in their supply chains better and give them a suite of tools that they're now using. Those are so popular, in fact, that many ASX-listed firms are now using the tools supplied by us to New South Wales Government. So we're getting better, but there's a long way to go, I would say, in actually being able to demonstrate that at a system level, we're reducing the risk at a system level. So not just removing the risk from a particular buyer, but actually removing the risk that, say, solar panels, for example, are made with modern slavery.
Also, solar panels is something that we need to be careful about when we purchase. Is that an example where you've seen instances of modern slavery?
They are one of the product categories listed as high risk in the inherent risk identification tool that we provide to government, yes.
Thank you. And how guilty should I feel when I pick up some fast fashion at a ridiculously cheap price?
I think I always like to say that the issue is a systemic one, and the system is made up of all of us. So we all have a role to play, but it is tricky. I'm on the public record saying when you go to buy your jeans and you look at the label, it's very hard to know where that cotton really comes from. So in my private consumer capacity, I'm fairly forgiving, but as officials, I think we all have an important role to play in shifting the system, and indeed that's what the legislation provides for, but there's a long way to go, and there'll be dedicated resources required across government to ensure that government is able to identify whether maybe not its fast fashion, but for example the uniforms that it's supplying are indeed made. And I would refer there to the important work that the Modern Slavery Committee is doing, including as a result of an inquiry that Dr. Kane championed into ethical clothing trade and the important arrangements there.
All right, thank you very much. It's very interesting. Thank you.
I think we're at the end of the session anyway for this. We'll break.
We've come to the end?
Well, for this session.
For this session? Okay. All right, we'll have a break now and come back in 15 minutes.
Thank you.
time again.
All right.
We'll start with,
Right, thanks.
with opposition. We'll get started again, please. Thank you.
I'm happy to. I just have a handful of sort of random type questions. One is the $5 million for the youth resilience to violence, violent extremism. And if that's a new program, I'm mindful it might be under youth justice, a new program or an extension of programs that are already in place.
Are you talking about the engagement and support program?
No, it's just listed budget paper. Just has the $5 million resilience to violent extremism, but no details.
Yep. I may have a note.
And is that, when you find it, is that run outside a correctional environment or inside a correctional environment?
There are 2 or 3 separate programs, aren't there, that we run?
Yeah.
Yeah, it's the overview, our plan for New South Wales, page 35, $5 million to deliver community-based initiatives to strengthen youth resilience to violent extremism.
No, I don't think it's in my patch. It's, I think, the youth justice one.
That's, I thought it might be.
Yeah.
What's it called again? Sorry.
Well, all it is named as is the $5 million for community-based initiatives to strengthen youth resilience to violent extremism.
I think the safest course is for us to take that on notice.
That's fine.
Thank you.
The other is, back to budget papers number 3, the regional key worker housing that is listed under works in progress.
I think so.
That is
Under housing?
Yeah, that would, I believe, a question for Mr. Jackson.
It's coming up next week, so.
Next Tuesday.
And then my final question before I hand over, actually I've got 2. One is the performance and wellness consultation paper. Mindful that there are sort of no targets or anything within it, but how is the department planning to, I suppose, measure what is expected? Will there be priorities listing, key targets, deliverable dates? Because the information that's provided is very, very vague.
I think so.
Yeah, that is a process we are working through with Treasury, and I think that where DCJ goes will be very similar to other agencies. It's a good question. I think we'll need to revert on notice though.
And if you could also take on notice just the time frame of when it's expected that the final, I suppose, whatever the plan is, will be announced following the consultation paper. The final questions. I've lost my page. It's in relation to the Office of the DPP, and I think it's capital expenditure for Wagga Wagga accommodation. I was just interested, obviously, with the Sydney location and what the Wagga Wagga location is for and why it's Wagga and nowhere else.
It's to expand our office in Wagga because we've outgrown it, is the short point, and we're taking some more space in the same building.
And are there any plans to expand into other regional areas at all?
Oh, look, we're outgrowing all of our offices at a pretty rapid rate, but we're trying to make do within our current budget in our other locations. But we have requested an increase in capital funding for some other offices. Some of that was not successful, but we will be renewing those efforts in the next budget funding round.
And which offices have you outgrown?
We really need more space at Parramatta and at Newcastle, also at Gosford. Well, pretty much all of our offices. Lismore is also tight. Of course, Sydney we're about to move, and even in Sydney, without even our space contingency, it'll be tight when we move in there.
And just a broad question around DCJ buildings and offices. Are there any plans of consolidating offices or DCJ regional offices in any way, or?
Not at this stage, to my knowledge, no. I mean, it was I believe in, and bearing in mind we're in the DCJ is a Hydra-headed entity.
Yep.
In terms of the functions that we're considering today, other than courts and the like, we are stable. In terms of the reference yesterday to districts, which fell within Minister Washington's estimates, there are changes to happen there occasionally. There will be some restructuring of districts, but that's a separate that attaches to separate estimates. So my answer is not to my knowledge.
Okay, thank you. I'll hand you to my colleague.
Can I just follow up on that? In terms of DCJ, what are the current guidelines and what percentage of people would work from home 5 days a week, 4 days a week, 3 days a week? What's happening in that space in DCJ?
Yeah, so we've had obviously post-COVID a number of people and flexible work in place, and that has been permitted. In terms of measurement and the percentage, I don't know that it would be possible to provide that figure even if I took it on notice, but clearly the Premier's circular issued on the 5th of August, to which I then the same day communicated with DCJ staff, indicated that whilst not mandating a specific pattern of attendance, the requirement was that office-based staff would principally work in an approved workplace. We have a flexibility framework within DCJ which was promulgated in 2021. We're in the process of, in consultation at the moment, aligning that with the clear expectation or requirement that staff will principally work in the office, i.e. at least 50% of the time. Anecdotally, although we don't have numbers in at this stage, anecdotally the evidence is that we actually do have a very healthy movement coming back. I believe that will be for the good of the organisation. Just quickly on DCJ, of course, the point to be made about DCJ is whilst the function that is subject to these estimates today is heavily office-based in a traditional sense, our workforce is very frontline based. So prisons, child protection, housing and other things, those things by necessity occur on the front line in prescribed workplaces, but separately the return to the workplace, it will be an important process to work through, but there is a requirement. We also want people to come back to the office, and therefore the way we consult and work with our staff is going to be important.
Yeah. Are you able, when you're looking at those figures, to separate out between frontline staff who really have no choice but to be at their workplace?
Yes, absolutely.
Yeah. Okay, thank you. And I wonder, Ms. Darling, if you could comment, something like the DPP, how possible is it for staff to work from home? Is there a hybrid pattern possible, or?
We have a flexible working policy that has a maximum of 2 days working from home, but that has to be subject to operational requirements, subject to approval from manager, and in an agreement in writing. We are a litigation law firm, and most of our staff have carry a litigation practice, so it's not that feasible to work from home.
I wonder if you could comment, and maybe Mr. Tidball, issues around working from home in terms of staff development, especially development of junior staff?
Look, it's certainly our view that there is a great deal of benefit from staff working together in the office, for those professional development opportunities, which are often just incidental from, seeing people in the tea room.
Mm-hmm.
And certainly we have a high number of fairly junior staff who do need that one-on-one mentoring with their peers and with their managers. Having said that, we are confident that we've got the balance about right.
Yeah. Just curious, because if you look at the legislation, and I have a very imperfect knowledge of it, you have an unusual structure in the sense because it's the ultimate decision making rests with you. So how do you approach, delegating decision making or developing those capacities for the touch and feel of a case, in a sense, with junior staff? How does that work in your sort of very unique role?
Oh, look, we have a very well-established network of learning and development and mentoring, and we have, as you no doubt know, almost 400 solicitors in the solicitor's office. We have 110 Crown prosecutors, and then we have a significant number of paralegals as well. So important decisions as to the prospects of conviction, for example, or the application of the prosecution guidelines, they are made subject to well-established delegations by more senior practitioners, and that learning of what's admissible, what the prospects of conviction are really like in a particular matter, that's a process that is learnt from a combination of knowledge of the law and experience in running matters.
But are there particular issues that you face? Because I'm just thinking, for example, in a typical bar practice, the barrister is the decision maker, whereas in a lot of circumstances, like the Crown prosecutors, they're not the decision makers, are they?
I disagree with the question.
Okay.
Important decisions in cases are made by the clients.
Okay.
So no barrister can ever terminate a matter without instructions from their client. Generally, in most cases, there's an instructing solicitor who is also very much involved in the important forensic decisions that are made in a case.
And so who's your client, as it were?
I am the client.
Right.
And the Crown prosecutors and solicitor advocates appear on my behalf.
Right. Okay. Interesting. Thank you. And Mr. Tidwell, do you have comments about development of junior staff if they're working out of the office, or?
Look, I would say that we have some leaders who have been, I don't say it for convenience sake, Paul McKnight has had a team of lawyers who have had significant time working, who haven't been in the office, working remotely, and what I've observed is the leadership. So belonging to it, it's been, where we're going, I think will be very good for the organisation, and a sense of cohesion and purpose and an alignment of office-based teams with our operational staff. Having said that, I've seen, fine examples of leadership and teams working, meetings. There have been ways of building cohesion and a sense of coordination and shared purpose, and checking in to ensure that staff are not feeling isolated, particularly staff who may be working on difficult matters, and there's been a process and a discipline around that in DCJ. Having said that, I think the movement back to having greater presence in the office will, as it plays out, I think be for the good of the communities that we serve.
Okay, thank you. I've just got some particular questions about the budget, and for your convenience, I'm looking at budget paper number 2, the agency financial statements, and I'm looking at 4.1. Crown Solicitor's Office, they're getting 38% less. Is it because they're more efficient, or what's happening there? Is there a reason for that?
Bear with me.
Yes, certainly.
I will need to take that on notice, if I may.
Right. If you could, thank you. And Legal Aid Commission are getting almost 40% more. Is that volume of work? Is that better deal for solicitors undertaking legal aid work? Do we know what that is?
I'm not familiar with the 40% figure.
Oh, it's 39.7, I
Ms. Carter,
apologise.
but we did get some funding in order to retain the same level of fees that we pay for private practitioners over the next 4 years.
Okay.
So without that funding, we would have had to revert back to the level of fees that we were paying in 2019, which was significantly less.
That would have created significant difficulties, I imagine.
And it would have, yeah.
Yes.
As well
yes.
as some other little items that we also got funding
Yes,
for this
yeah.
year. Yeah.
So, Ms. Hitter, so the community legal centres, they're funded through legal aid as well, I understand?
We administer the funding.
Mhm.
The funding is allocated by government, by
Right.
both the Commonwealth and state government, and also the Public Purpose Fund also provides some
Okay.
funding for CLCs, and we just administer the funding as it were.
Because, and I apologise, I'm not as up to date as I would like to be on this, but there have been some difficulties with the funding of the Broken Hill CLC. Are you aware of where that is at?
I am.
That's very helpful.
Not so much difficulties with funding the Broken Hill CLC. It was more that the provider, the CLC provider, indicated to us that they no longer wanted to continue to provide those services.
And
so
they were contracting them out to another CLC, I believe?
Well, in the interim period,
Yes.
until we got a new provider, they were contracting them out to another provider.
Yes.
And we are now providing funding through the CLC program to that new provider.
So there was no break-in service?
Not as far as I'm aware.
That's
right.
great.
Can I just distinguish in the paper from which you're reading
Yes.
between expenses and capital? So
yes.
the Crown is has minimally moved, the Crown Solicitor's Office.
Oh, you're right, I'm looking at the CapEx.
And
Apologies.
there is a significant increase, decrease in capital for the Legal Aid Commission of New South Wales.
Right. Yeah, no, thank you for pointing that out. Yes, okay. But the Office of Sport, about which you probably can't help me, gets 25% more in operating expenses. What are they doing in the Office of Sport?
They are no longer part of the consolidated entity, or they're no longer
Right.
a related entity. They've been subject to a MOG change.
Right. Yeah, no, I wasn't expecting you. I just glanced down the page and saw that and thought, very interesting. Very sad to notice the black hole that is the Home Purchase Assistance Fund, but we'll move on from that. So the Judicial Commission, so no change in their operating expenses, 66% change in their capital expenditure. What's happening at the Judicial Commission?
Can I see that? It's a very small budget.
Right. But what are they doing that they need 66%
could
more
be
of it in capital?
Could be technology, wouldn't it?
It could be
I'm
technology, it could be
speculating.
fit out.
Could be technology.
It's $100,000.
Yeah.
in-
Could you
in
take that on
cost.
notice?
Happy
maybe?
to take it
Yeah,
on notice,
thank
yes.
you. It's just that when you see big variations like that, it's
Yeah, of
just
course.
interesting
Yeah.
to know
Yep.
what they're for. And the Office of Children's Guardian, they're down 8% in operating expenses, 661% change in capital expenditure. What are they doing?
This was subject to questions yesterday in Minister
Oh,
Washington's
okay, apologies.
estimates.
Yeah.
Yeah.
Can you just give me a highlight, so just for my curiosity?
From memory, I think it's to do with fee structure
Yeah,
and fee
fee
revenue, a
structure.
substitution of quality consolidated revenue as opposed to fee revenue.
Right, okay, thank you. I'll pull the transcript and have a look at it. And the DPP, perhaps Ms Dowling or Mr Tidball, 15% higher operating expenditures, 60% higher capital. Is that WAGA or is that other things?
Look, I don't want to misstate it, but that will be a combination, I think, of Sydney relocation and WAGA.
Okay,
But
okay.
I'll clarify that.
Thank you, that'd be good. And we should expect, well, we should hope to see a similar figure in other years as other
That would be good.
right? And this is because you've got a growing workload, or?
Yeah, I'm just about to text.
Okay, thank you. Oh, sorry, is it time? I've got a couple more questions. Is that
Do you want to proceed with those questions?
If that's okay? Yeah, okay. Great, good. And actually, good place, because I just have a couple of questions for you, Ms. Dowling. And this was raised this morning, and perhaps you've had a chance to have a look at it. Keeping on, I believe.
Let's give you a warning.
Right, thank you. All right. 93IB and 93IC of the Crimes Act. How many matters have you been asked to deal with? Like, how many have proceeded by way of indictment?
I know that we do have a number of matters. My understanding is that they are attached, or they are part of other offending. I don't know how many we've got. I'll have to.
Okay, is it possible to get those figures? No, that would be very good. Are you aware if you've declined to accept the recommendation of the police on any occasion to proceed by way of indictment in relation to a 93IB or 93IC?
I'm not aware. I can.
If you could
look into that.
Provide that would be great. Thank you very much. And are you aware of the outcome of any prosecutions that may have taken place?
Again, I can make those inquiries.
Thank you. We had interesting testimony on Friday. I don't know whether you're aware of this, from Deputy Commissioner Hudson in relation to Section 93Z, and he indicated that there were 2 or 3 matters that they had run in error because they didn't realise the legislation as it then was required your office. And as I understood the testimony, they had been successfully run, convictions achieved, and they realised that they shouldn't have been brought in the first place. They were then referred to your office, and I understand a decision was made not to proceed with those. I'm just curious, why, when convictions have been achieved, would your office be recommending against?
My information is that perhaps there's an error with the police information. Those matters were as you say, charged without sanction. There were pleas of guilty entered. Then it was realised that they were nullities because of the lack of sanction, and so they were annulled under Section 4 of the Crimes Appeal and Review Act.
Thank you. I was wondering how that happened. Thank you.
So that process is one that was conducted entirely by police. Those matters never came to the ODPP.
Yes.
And they have never been referred back to us. So they are not with my office and have never been with my office.
Okay, because the information we got on Friday, estimates next time, I suppose, because we clearly got evidence that they were and you had declined, and I was just curious as to why that would happen.
Yeah, no, I've made those inquiries today and they've never been referred.
Okay, very interesting. Thank you very much. Has the ODPP made a submission to the Law Reform Commission in relation to 93Z of the Crimes Act?
Yes, they have.
Okay, great. Thank you very much. Is that submission public?
I'll have to check that.
All right.
The Law Reform Commission normally publishes its submissions online, so it's likely to be there.
All right, thank you very much. Thank you. And last time you told us about the audit of the sexual assault cases, that's been completed?
Not quite.
Okay.
It's almost completed. I gave some evidence earlier when you were out.
Oh, apologies, I was out. Okay. If you bear with me, the audit was performed by whom?
It's a review, and it's been performed by senior Crown prosecutors, deputy senior Crown prosecutors, and deputy directors.
Okay, so people within your
Yes.
office. Okay, and was there? Are you able to share any of the results with us so far?
Yes. The 330 matters have been reviewed. There are 353 matters that fell within the established scope. 23 of those matters had already been referred to chambers for consideration.
Sorry, could you explain what that means?
That means that those 23 matters had already been identified as ones where the prosecution team were concerned about aspects of the prosecution, whether that's evidentiary or discretionary. So they were already with a deputy director for consideration.
And sorry, I'm just trying to understand it. What is the possible outcome of that consideration?
After committal,
yes.
Under the DPP Act, the only person who can discontinue a prosecution is me or a deputy director, and that power cannot be further delegated. So these 23 matters had been identified as ones where perhaps in the view of the prosecution team, which is the solicitor with carriage and the advocate who will be appearing at the trial, that they may be matters that should be discontinued. So they were already being reviewed by a person with the appropriate delegation to make that decision. So they weren't included in the scope of the review.
And the review is against the ODPP prosecution guidelines?
It's in relation to the application of the prosecution guidelines. And you'll recall the circumstances in which the review was
would those
called.
prosecution guidelines have been engaged when there was a decision to proceed to committal in respect of those 23 matters?
Yeah, the committal test is contained in the Criminal Procedure Act, and it is expressed in section 66, subsection 2 of the Criminal Procedure Act. It's expressed as, is there evidence available to the prosecutor that is capable of establishing each element of the offence? Notwithstanding that is slightly differently worded to the prosecution guideline test, which is reasonable prospects of conviction and the public interest. The prosecution guideline test applies equally pre-committal, so at that charge certification time. And that's in fact one of the learnings that we're getting from the review, is that total coincidence of those two tests would be preferable.
Yes.
So to answer your question, the prosecution guidelines apply, that prosecution guideline test applies at every stage of the prosecution, pre-committal and post-committal.
But with the matters that are referred, there's a concern that they're either understanding has changed, evidence has developed, or that perhaps there was a misapplication?
No, so I was answering your initial question about scope. There were 353 matters that fell within the scope, which is listed for trial between the 1st of April and the 31st of December this year. Of those, 23 matters had already been referred to Chambers, so they were taken out of the review. And the remaining 330 matters were then reviewed. Of those matters, 15 matters have been terminated, 8 on evidentiary grounds and 7 on either discretionary grounds or a combination of discretionary and evidentiary grounds. And as I was giving evidence earlier this afternoon, I'm not able to inform the committee in relation to the evidentiary grounds, whether that's as a result of a change in the evidence post-committal and pre-trial. But it is my belief that it is likely that all of those matters would have been identified in the lead up to the trial, because that is the routine process within the ODPP, is that as matters are prepared for trial, bearing in mind there is often new evidence that is served by police or arises out of conferences, the prosecution, the question of reasonable prospects is constantly being assessed. Hence the discontinuation of some matters fairly close to trial or even during trial as evidence changes.
And so it's being reassessed by the solicitor and the Crown Prosecutor working as a team?
Yes.
Right, and then there's a referral mechanism to go to Chambers?
Yes, the non-review mechanism is that the prosecution team will write an initial report, then there'll be a second report by the advocate who is running the matter.
Right.
Then it will be referred up to Chambers. It'll be then assessed for a third time in Chambers, and a decision will be made by
if there's a disagreement between the solicitor who makes the initial assessment and the advocate who makes the second assessment, does it still proceed, or what happens?
If it's post-committal, that will still come up to Chambers.
Okay.
And then the decision is made by the Deputy Director or by me.
So the solicitor and the advocate are not involved with the committal, the decision to proceed to committal?
That's the EAGP process.
Right.
So that's the charge certification process, which is the first stage.
Yes.
Once a matter is certified and committed, it then moves into the District Court or the Supreme Court. The prosecution team remains with it, so the same lawyers remain in it in an ideal world, but there is, of course, often a necessity to rebrief.
Yeah. Look, I'm just curious, and I don't know whether you've thought about this. If you had a situation where the solicitor recommended that it proceed. The advocate didn't believe that there were reasonable prospects of success, or there was some reason didn't believe that the matter should proceed. But the ultimate decision was that it would proceed. I mean, in what circumstances could that advocate ask to be reassigned, or because it's a sort of an unusual employment situation, they're required to comply with directions? What sort of scope do they have as barristers as well as employed Crown prosecutors?
They have the ethical obligations under the bar rules, and it is always open for a particular advocate to approach me as the client and say that they feel that they can't remain in the brief. However, if that's because of a personal view about the quality of some evidence, then under the bar rules that would not be a sufficient basis. But it's, people are not being forced to run matters in my office.
So it is entirely possible for a Crown prosecutor to come to you and say, for whatever reason, I don't believe that this matter should proceed, and ethically I don't believe that I should be running this matter.
In that case, what I would do, and it hasn't happened to me since I've been the director.
Sorry, it has never happened?
It has not happened.
Okay, thank you.
In that case, what I would do is I would invite the advocate to explain to me in writing which part of the bar rules prevent their continuing in the matter.
And then, I mean, I understand it's hypothetical. What's the likely next step in that situation?
Well, I'd consider the report and make a decision.
Yeah, okay, thank you. I don't have any other questions. Susan?
No more questions? Okay, I think we've come to an end then, an abrupt early end. I note that we've taken a certain number of questions on notice. The Secretary will be in contact with you about appropriate answers and timing. Thanks very much for coming today. That'll be it. Thank you.
Thank you.
Great, thank you.
Thank you.